May I please, Lordship?
Yes.
Lordship, I beg to mention item number 50. Lordship, the affidavit is prepared, Lordship, is sent for vetting.
15 or 50?
50.
50.
It's regarding the implementation of the CAG. Lordship, last time I have mentioned,
Okay.
Comptroller and Auditor General of India. In a criminal case, they have been implemented as a party, Lordship. So I have sent for vetting, so at least 4 weeks it may be granted, Lordship, because it has come from Delhi, Lordship.
4 weeks.
4 weeks.
Yes. Because I don't want to take another time, Lordship, because of delay of filing of the affidavit.
Learned Counsel, Mr. Ed Muzi, appearing for respondent number.
It's number 8, I believe. 7.
Please, for a month's time to file his affidavit as the same has been sent to Delhi for vetting. So, Learned Counsel for the petitioner, Mr. Fosiko is present. List after, and Learned PP, as Mary is also present.
My lady, there's an interim.
List
Can let him
after
continue.
4 weeks. So, the interim order passed earlier shall continue till the next date. Yes.
Oblige, Lordship.
Oblige, my lady.
May I please, Your Lordship?
Yes.
I'd like to mention item number 22 to 41. Let the matter come up after 3 weeks.
22 to 41.
41.
Lordship, there is a similar a writ appeal which is pending before the division bench for the similar question of
matter.
law. Yes, my lord. Writ appeal 7, I think, of 2025.
Then we can list it after the disposal of the writ appeal.
Let's say for after 3 weeks for the time being, my lord.
Okay. On the prayer of the Learned Counsel for the petitioner, list the matter after 3 weeks. For admission hearing.
Yes, my lord.
This is for admission.
Yes, my lord.
For admission. So, Ms. Learned Counsel for the respondent, Mr. Cynthia is present. Yes.
Deeply obliged.
Deeply obliged.
May it please your Lordship.
Yes.
Lordship, I beg to mention item number 55, your Lordship. Lordship, I beg that the matter be listed after 2 weeks, your Lordship. Hearing matter.
List the matter after 2 weeks on the prayer of the Learned Counsel for the petitioner. Yes.
Lordship, I also beg to mention item number 2, your Lordship. Lordship, here, Senior Advocate, your Lordship, is in dispose of your Lordship. If the matter can be listed on that unison, your Lordship, with the other analogous matters.
You're for the petitioner?
Yes, your Lordship.
Okay.
Other matters are listed on that 27. So,
27th.
27.
Learned Counsel for the petitioner, Mr. M. Solo, makes a mention on behalf of the leading counsel, Senior
Das.
Advocate Mr. D. Das, who is indisposed today, and prays for listing the matter on 27th along with other similar matters.
Lodge.
Yes.
Much.
Learned PP, Mr. K. Angami, has no objections. List on 27th.
Lordship. Much.
Please, my lady, I beg to mention item number 47. I have instruction to appear on behalf of respondent number 4, who is newly implemented. So can you grant me 4 weeks time to file my wakala nama as well as to obtain the instructions?
Learned Counsel for the petitioner, Ms. Tsela Kips is present. So, Learned Counsel, Mr. K. Angami, appearing for the respondent number 4. No, Mr. K. Angami submits that he has received instructions to appear on behalf of the newly impleted respondent number 4 and prays for
4 weeks
4
time.
weeks time to file his power as well as the affidavit. So, prayer is allowed, list after 4 weeks. Yes.
Yes, please, my lady. My lady, I'm appearing through PC. My lady, I'd like to mention admission item number 7 and hearing item number 44. I have the consent of the other side, my lady.
Admission item number 7.
7.
7 and
And hearing item number 44.
no, isn't admission 7 is,
What is this?
I think you're not a party in item number 7 admission, because this is clubbed up together with a whole list of other petitions which are part heard.
Right.
Yes, my lady. I'm sorry.
Okay, then hearing item,
Hearing item 44.
hearing item 44. No, that is also, because hearing starts from 52.
Your Lordship, there is a revised cost list. I think he is having the old cost list, yes. Item 44, I'm respondent here, my Lord.
Yes, item 44 is, yes, you get hold of the revised cost list.
Okay. Sorry, my lady.
Yes,
Yeah, please, Your Lordship. Your Lordship, in item number 42, I have an instruction to appear on behalf of the respondent, Lordship.
42.
Yes. So kindly allow me 1 week
On
time.
behalf of respondent,
Yes, respondent.
Learned Counsel Mr. Tushi Temjan submits that he has received instructions to appear on behalf of the sole respondent.
Lordship,
Where is the petitioner?
Your
42.
Lordship is in court 1.
Okay. Receive instructions to appear on behalf of the sole respondent and prays for how much time?
1 week time
1
to
week
file
time
my
to file
work
his power and the affidavit. Stop list after 1 week. Yes.
Much obliged.
May I please, Lordship. My Lord, I beg to mention item number 51 on behalf of Subongla. My Lord, I'm informed that she is appearing for respondent number 3. So she sought for 3 weeks' time, my Lord, to file affidavit.
Learned
51.
Government Advocate Mr. Thibapom makes a mention on behalf of Ms.
Sabongla,
Cham,
yes.
who will be appearing for respondent number
3, yes.
and accordingly to list the matter after
3 weeks, my Lord.
3 weeks. Stop. List after 3 weeks in order to enable the respondent number 3 to file the affidavit. Yes.
Much obliged.
May I please, my Lord? Lordship, I beg to mention item 19 on behalf of V. Shokre, Your Lordship. If this matter can be listed after 2 weeks, Your Lordship.
Petitioner?
Yes, I have no objection.
No objections. Learned Counsel for the petitioner, Mr. L. Ralu is present. Learned Counsel, Learned Government Advocate, Mr. K. Angami mentions.
N. Angami, Your Lordship.
N. Angami makes a mention on behalf of Ms. V. Shukre to list the matter after
2 weeks, my
after
Lord.
2 weeks. Stop. Praise the Lord. List after 2 weeks. Yes.
Lordship, I also beg to mention item 46, Your Lordship. In this matter, I have instruction to appear for respondent number 5 as well, Your Lordship. If 3 weeks' time can kindly be granted to receive the necessary instruction, my Lord.
Learned Counsel, Mr. N. Angami submits that he has received instructions to appear on behalf of respondent number 5 and accordingly prays for 3 weeks.
Yes, my
3
Lord.
weeks' time to file the affidavit. Stop. Prayers allowed. Learned Counsel for the petition is present. List after 3 weeks. Yes.
Deeply obliged, my Lord.
My pleasure, Lordship. Lordship, I beg to mention item 54.
Yes.
Lordship, let this matter be listed after 3 weeks, Lordship.
After
3 weeks, sir.
3 weeks. Learned Counsel for the petitioner, Mr. You are for the petitioner?
Yes,
Learned Counsel for the petitioner, Mrs. Francis present. Learned Counsel for the petitioner prays for 3 weeks' time. Stop. Accordingly list the matter for hearing after 3 weeks. Learned Government Advocate Mr. T. Bhum is present.
Operation. Much obliged.
Yes.
May I please, my lady? My lady, I beg to mention admission item number 21 and hearing item number 57.
Admission 21.
21
21.
and
Yes.
hearing number 57.
Hearing.
I have the question of the other side. my lady.
Yes. When do you want?
After 4 weeks, my lady.
After 2 weeks.
4, my lady.
Your Ladyship, I'm appearing for respondent claimant. It can be fixed on the
We
20th.
cannot hear you properly. When do you want it?
My lady, if it can be listed after 4 weeks.
Learned Counsel for the petitioner in petitioner and we put admission and hearing item, okay? Admission 21 and hearing item 57. Oh, 57, we'll just pass one by one. 21, Learned Counsel for the petitioner prays for 4 weeks' time. So, prayers allowed list after 4 weeks. And you're appearing in 21.
Yes, sir.
Learned Counsel, such and such, appears for the respondents and has no objections. So then come to item 57. Learned Counsel for the respondent, Mr. V. Debnath, prays for 4 weeks' time, which is not objected to by the Learned Counsel for the petitioner. It's a such and such list after 4 weeks for hearing. Yes.
May I please, Your Ladyship. Ladyship, I beg to mention items 43 and 45. Your Ladyship, here we have filed our objection, but it was rejected because of some technicalities. So we will be filing the corrected objection by this week. So if the matter can come up on the 27th of October. Items 43 and 45.
43 and 45.
I'm for the respondent claimant.
Okay. Learned Counsel, sir, for the respondent claimant submits that he had filed the objections which were rejected due to certain technicalities. And therefore he has prayed for how much time?
If it can be listed on the 27th, we'll be filing it this week.
Okay. 27th? Yes. Okay. He has prayed for listing the matter on 27/10, and he prays for permission to file the objections before the next date. So, praise allowed. Learned Counsel for the appellant, Mr. Foseko, is present. And in 43, Learned Counsel for the appellant, Mr. James Mai, is present. Yes, both on 27th.
Your Ladyship, similar prayer for item 20. Item 20.
20. Okay, item 20, same order to file the objections and list on the same day. List on 27th. Yes.
Much obliged, Your Ladyship.
May it please, Your Ladyship, I beg to mention item number 44. Ladyship, here kindly allow us to file an application for impleadment of the incumbent AG. So, if 2 weeks' time may be granted.
AG Accountant General?
Yes, Accountant General.
Learned Counsel for the petitioner submits that she will be filing an IA for impleadment of the Accountant General and accordingly to list the matter after
2 weeks.
After 2 weeks. Stop. List after 2 weeks. Learned Counsel, Ms. A. Hayumi appears for
Respondent 3, 4, 7, 8, and 9.
3, 4, 7, 8, and 9, and Mr. N. Nangami
For respondent number 1.
Respondent number 1. Yes.
Obliged.
For motion, item number 1.
Yes, what is this? Yes.
May I please, Lordship,
Yes.
the criminal revision petition is directed against the order, impeachment order dated 3/10/2025, passed by the learned special judge NDPS Kohima in IA 141 of 25, where the demand application of the petitioner was rejected on the ground that he was not legally entitled to possess a vehicle, though he was the lawful owner, as he have purchased the said seized vehicle from the previous owner, in whose name the RC still stands. But, Your Honor, the learned special judge have failed to consider that I was the lawful owner, despite my statement given to the IO of the case, and there was no objection from the IO regarding the ownership of the vehicle. I have annexed a cell deed as Annexure 6, page 34, Your Honor.
Where is the impugned order?
Impugned order is page 20, Annexure 3.
Your name was not transferred in
Yes,
the
my lord.
records. That is
Yes, my
why
lord.
it has been rejected.
Yes, my lord. My lord, I have also submitted one case law, which is Sat Singh versus State of Punjab and others, which was disposed by the learned Punjab and Haryana High Court, where it was decided that if the registered owner have given the possession of the vehicle to the purchaser, then that purchaser have superior claim over the seized vehicle. That case was not considered by the
Yes,
learned
Mr.
special
Chair.
court.
My lord, let the notice be issued, my lord.
The present application has been filed under section 438/442/528 BNSS, read with section 497/503 BNSS, praying for quashing and setting aside the impugned order dated 3/10/2025, passed by the learned special judge NDPS Kohima in IA 141/2025, arising out of Kusama BS case number 6/2025, corresponding to special case number 17 of 2025 under section 22 clause C NDPS Act, read with section 3 clause 5 BNS. Stop. Issue notice returnable within 4 weeks. So on the returnable date, the learned public prosecutor, after that, heard learned counsel for the petitioner, Mr. Bakrin Chapu, and also the learned public prosecutor, Mr. Tibapong. So on the next returnable date, the learned public prosecutor shall obtain updated copy
Yes,
of
sir.
the case diary. So at least after 4 weeks.
Much obliged.
For motion, item number 3.
May I please, Your Lordship? With due respect to Your Lordship's permission, I would like to withdraw this contempt petition. My Lord, I have identified that there are some inadvertent errors in this contempt petition, which could also potentially affect the integrity and clarity of the proceedings. So,
Learned counsel for the petitioner, Ms. Aratzela gives pleas for withdrawal of the present petition.
with the liberty to file
With
afresh, my
liberty
Lord.
to file afresh, so prayer is allowed. Matters disposed of and withdrawn.
Highly obliged, my Lord.
For motion, item number 4.
Petitioner is at liberty to file afresh. Yes.
Yes, my Lord. This contempt petition is filed for non-compliance of this Honorable Court order dated 1/7/2024, where this Honorable Court has directed the respondents to regularize the petitioner in terms of the standing OM 17 of March 2015, and also with respect to the Umatevi's case within a period of 12 weeks. That is, 12 weeks is equivalent to approximately 3 months, my Lord. But the respondents have not complied with the order yet.
Order is dated
1/7/2024, my Lord. Annexure 1, page 9.
on 7/2024, within a period of 12 weeks from the date of passing of this order.
Relevant paragraph is page 13,
Yes,
paragraph.
yes, para 6.
Yes, Your Lordship.
Learned counsel for the petitioner, Ms. Atsela Gibbs. Stop. Para. This is an application praying for initiating contempt proceedings under section 11 and 12 of the Contempt of Courts Act 1971 and the Gauhati High Court rules, read with Article 215 of the Constitution of India, for alleging willful disobedience of this court's order dated 1/7/2024, passed in WPC 238/2022. Stop. This court, by order dated 1/7/2024 in WPC 238 of 2022, had directed the state respondents to consider the case of the petitioner for regularization and service in terms of the OM dated 17/3/2025, within a period of 12 weeks from the date of passing
And
the
also,
order.
Your Lordship, as per paragraph 53 of Uma Devi versus State of Karnataka, that may also be reflected, my Lord.
But that is not there in the operative portion. The direction is at para 6, and direction is only to consider in terms of the OM dated 17.3.
Yes, Lordship,
So we
then that will
reflect
suffice,
that,
yes.
OM dated 17.3 within a period of 12 weeks from the date of passing the order. Stop. It is submitted that in spite of, now it is how much time after the order?
It's
In spite
almost
of,
a year
in
now.
spite of the expiry of 12 weeks, stop, the state respondents are yet to comply with the direction of this court. Stop, hence the present petition. Stop, issue notice to the respondents 1, 2, 3, 4, and 5, returnable within 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service on the respondents by registered post as well as usual process within 3 working days from today. Stop, list after 4 weeks.
Deeply obliged, my Lord.
For admission, item number 5. 5 to 16, Potter.
Yes, who will submit today? We'll take up that.
I intend to submit, but then since there are few part 1 matters, this matter is likely to take some time.
Yes,
So
yes,
the
we will.
other remaining part 1 matters may be taken up first,
Suppose you call out the other.
except the hearing once, Lordship.
For admission, item number 18.
Yes.
May I please, Your Lordship? Lordship, here in this case, the notice are completed. As such,
Okay.
this case may be admitted and the trial court record may be called for.
But where are the other parties?
Lordship, here in this case, respondent number 3, it is 6 party. And performer respondent number 4,
4 is appearing.
Mr. Phoseko was appearing.
Mr. Medover. Okay. Learned the ex-party order is there for respondent 3.
Lordship, yes, sometime.
Order dated.
Yes, Lordship, order dated 5/6/2025. May I read the order, Lordship?
1 minute. 5/6/2025.
Yes.
Yes.
Lordship, it is submitted by Mr. Muaz Jamir, learned counsel appearing on behalf of the council for the applicant that steps have been taken on the respondent number 3 and the affidavit has been filed yesterday. Accordingly, notice on respondent number 3 is deemed served. Learned counsel for the respondent number 4, Mr. Bedo, is present and he prays for some time to file wakalatnama. So Lordship, here in this case, justice summon was issued by this honorable court. So
And then
accordingly, the
complaints
summon,
affidavit was filed.
Lordship, yes, the summon was acknowledged by the respondent number 3, and in spite of acknowledging the notice, they have not appeared, and accordingly, I have also filed affidavit.
Learned counsel for the petitioner, Mr. B.B. Chetri is present. Stop. The notice on respondent number 3 has been deemed served by an order of this court dated 5/6/2025. Stop. The respondent number 4 is represented and
By Mr. Posoko.
Mr. Medovero
Yes.
has entered appearance on behalf of respondent number 4. Mr. Y.P. Gupta has entered appearance for respondent number 1 and 2. Stop. Accordingly, the notices on the respondents is complete. Stop. The appeal is admitted for hearing. Stop. Call for the trial court records from which court?
Motor Accident Claims Tribunal, Dimapur.
From the Motor Accident Claims Tribunal, Dimapur. Stop. The list the matter after 4 weeks.
Lots of
4 weeks upon
obliged.
receipt of the trial court reports.
For orders, item number 48.
They were supposed to file your affidavits.
Lordship, here I am yet to file a power. In the meantime, respondent number 2 has already transferred. So the petitioner has to come forward for amendment of the petition of the course title. Respondent number 2 is.
You were appearing for 2.
Yes, 2. Earlier it was Anup Kinchi, and now the Abhijit Sinha, he has posted as a Home Commissioner.
Lordship, I have already implemented.
No, yet. Another one, James K, you have completed, but this one I think yet to.
Let's see.
Not yet completed, I think. But in any case, isn't it complied already?
No, it is in the process, but now the procedure has to be complied with.
Learned counsel for the petitioner, Ms. Z. Zimomi is present. Stop. Learned counsel, Mr. M. T. M. Song, appearing for the respondent number 2, submits that the respondent number 2 has been transferred out from the Home Department.
Lordship.
And the new incumbent has taken over. Have you checked?
Every month changing.
What to do? Stop. The learned counsel for the petitioner is
We will implead.
allowed to implead the new incumbent Home Commissioner.
Lordship.
Learned counsel, Mr. N. Angami, appears for respondent number 1. Mr. N. Longcomer appears for respondent number 3. List after 2 weeks.
2 weeks.
2 weeks.
For orders, item number 49.
Same issues, Your Lordship.
Same.
Yes.
Same order. And same councils also.
Yes.
Yes. Okay, same councils.
Same council and same steps.
After 2 weeks.
For admission, item numbers 5 to 16. Ordered.
May I please, Your Lordship? Sorry for interruption, my Lord. Item number 58, hearing item number 58 there. Since I'm informed that this item will take time, so my Lord, item number 58, kindly allow me to place only one status report, my Lord.
Which?
58.
Item 58.
Yes.
But petitioner?
My Lord, here.
Petitioner is not there. What do you want to show?
My Lord, here, in the last occasion by order dated 23/9/2025, this Honorable Court directed the accused to appear before the IO on 7/10/2025. However, he was not appear, my lord. This is the status report submitted by the IO, my lord.
Lordship, he has already appeared regarding one anticipatory bail application, Your Lordship. In this case, this criminal petition was filed first. Then later on, the interim prayer was not allowed. So anticipatory bail was filed. In that anticipatory bail, the IO called for the petitioner. In that bail, same petitioner, he appeared, and his written statement was recorded, Your Lordship. So there's no more need for him to appear in this criminal petition. His statement is also already recorded. And that bail was also made regular, Your Lordship.
No, my lord. My lord, here in the anticipatory bail order, the accused has submitted that has given assurance that he will appear as and when called by the investigation officer. So when the IO is calling the accused, he should have appeared, my lord.
Anticipatory bail, that is a different thing.
Yes, my lord.
But here, the investigation is going on.
Yes, my
So
lord.
every time you are summoned, you will have to appear before the IO till the investigation is over.
Lordship, I was informed by the leading counsel that on the previous date, when the petitioner appeared before the IO in Dimapur, he was threatened and beaten up, Your Lordship, by the informant. So that is why...
No, that is wrong submission, my lord. That is wrong.
So he is hesitant to appear before the police station physically, Your Lordship. And on the previous date, liberty was given to appear.
My lady, I'm appearing for the private respondent.
Yes, okay.
The statement made by my learned friend is absolutely frivolous. Beaten, not at all, my lady. After securing interim protection, investigation is still on, my lady.
When he's not
It has not been charged yet. Now, how can the accused himself say that investigation is his presence is no more required?
Till the investigation is going on, you will have to appear.
On two occasions, my lady, this Honorable Court has been very
When the IO
considerate.
summons, you have to appear.
Now, can the accused say that his presence is no more required?
He is willing to appear through VC, Your Lordship, virtual conference.
Yes, the order is there, 23-9. You were directed to appear on 7-10 at 1 p.m.
Lordship,
But-
about 12 minutes of talk was taken place, Your Lordship.
No,
12
my
minutes.
lord. No, he's not beginning
that
to call
was-
also.
That
Yes.
was before 23-9.
Yes.
Before 23-9, there was a video call, but they could not talk properly. The IO could not talk properly. So this court directed the petitioner to appear before the IO on 7-10-25
Lordship,
personally,
Lordship,
but he did not appear.
Lordship.
My lord, here even the IO has given assurance that they will provide security. But he's not cooperating, my lord.
You provide security and bring him.
Yes,
The
my
court
lord.
will direct. Yes. Heard learned counsel for the petitioner, Mr.
Medovero.
Medovero. Stop. Also heard Mr. Tiba from learned PP and Mr. Sensaj, the private counsel for the private respondent / complainant. Stop. The learned PP at the outset has produced a status report dated 12-10-2025, stating that the petitioner has not complied with the order of this court dated 23-9-2025, by which he was directed to appear before the IO on 7-10-2025 at 1 p.m. at the Tipupar police station and to record his statement. Stop. The learned counsel for the petitioner submits that the petitioner could not go to the police station as he was threatened by the complainant, which is denied by the learned counsel for the complainant / respondent. Stop. At this stage, it is relevant to mention that the petitioner had been granted pre-arrest bail by this court on 12-2025. Stop. However, the investigation is still continuing and the petitioner is under an obligation to appear before the IO as and when summoned. However, the petitioner has failed to appear before the IO as directed by this court by order dated 23/9/2025. So accordingly, the petitioner is directed to appear before the IO again on on
On 17, my lady?
17th.
Yes.
Okay. On 17/10/2025 at 1 p.m. at the Tipupar police station, and the IO of the case is also directed to provide security to the petitioner if so required.
Yes, yes, my lord.
List on 22nd.
Okay, my lord.
List on 22nd then.
My lord, 22nd is division day. Lord.
Oh, okay,
23rd.
23rd then.
Much obliged.
Apology, my lord. My lord, I beg to mention item number 52 and 53. My lord, if this matter can come up on after
On 27, Your Lordship.
27th. On the prayer of the parties, list the matter on 27th then for hearing.
Item number 5, please. Let the counsel for the UGC submit first.
Okay.
I'll take only 5 minutes, my lord. I've been implemented as respondent number 12 in 188, which was taken up the earlier, the previous day,
12 in 188, no?
2023.
You are a respondent in all the petitions?
No, I've been implemented only in
Only in 188?
188, 2023.
The Honorable Court directed for implement only in this 188, but it can cover the whole thing since it's all
Yes,
the same
yes,
allocation.
yes. But their submissions in 188 can cover?
Yes.
Yes.
More or less.
Yes. Yes.
Lordship, I filed my affidavit for Lordship first. I'll rely on only 2 paragraphs.
Respondent 5.
12.
Oh, 12. This is 188, no? Just see for the affidavit of respondent 12 whether it's there. I cannot find it here. Oh, yeah, it's here. Yes, respondent 12.
I'll be relying on only 2 paragraphs. That is paragraph number 10 and 11. More or less, the counsel for the petitioner had made submissions to these regulations.
10 and 11.
10 pertains to the clause 3.1 and 4.1. That is regard to the direct recruitment qualifications, my lord.
Yes.
And just clarification, I have the documents that I've annexed with regards to the regulation of 2018. So 2010 and 18, they are almost identical.
Almost same.
Identical. Since the petitioner in this present 188, they have been appointed before 2018. So I'm just referring to the 2010 are also equal. So Lordship has got it, Paradigm?
Yes, Paradigm.
That the answering deponent most respectfully refers to clause 3.1 and 4.1 subclause Roman I of UGC regulations on minimum qualification for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education 2018. Clause 3.1 of the regulations 2018 provides that the direct recruitment to the post of the assistant professor such and such in the universities shall be on the basis of merit through all India advertisement. And Lordship, next paragraph. Clause 4.1, Roman I of the regulation 2018 for the eligibility. This is eligibility criteria. I will not trouble you, Lordship. Next page, para 11. This is important. That the answering deponent further refers to the clause 13 of the UGC regulation 2018, which provides for appointments made on contractual basis and is self-explanatory and mandatory in nature. And I've quoted the 13 clause, appointment on contract basis. The teachers should be appointed on contract basis only when it is absolutely necessary and when the student-teacher ratio does not satisfy the laid down norms. In any case, the number of such appointments should not exceed 10% of the total number of faculty positions in a college, university. The qualifications and selection procedure for appointing them should be the same as those to a regular appointed teachers. That is all India advertisement. The fixed emoluments paid to the such contract teachers should not be less than the monthly gross salary of a regular appointment assistant professor. So, Lordship, this much is relevant. So, in my respectful submission, my Lord, the guidelines which are issued by the UGC from time to time are mandatory in nature and cannot be overlooked at any stage. That's all, my Lord. Obliged.
Please, Your Lordship. I am appearing in 8 cases. In all the 8 cases, I am not appearing for all the respondents. So I am appearing for the selective respondents. A chart has been furnished the other day. If it is not there also, today also I can supply that chart. The number of cases have been given, and then the subject-wise, because the writ petitions were filed subject-wise. And then the number of respondents for whom we are appearing, I have mentioned.
I think
I'm furnishing the chart.
it is already there.
Yes, I think it is already there. It's there. On the last occasion, I was expecting that my learned friend will explain in detail about the different stages of litigation. This is the 3rd round of litigation on the same issue, on the same subject matter. That is one. First, under the nomenclature of account, Lordship is well aware, that was very popular few years back. But as we all know, how sustainability is the NGOs in Nagaland. So they have filed questioning the same thing which they have raised even in the present writ petition. Preliminary objections were raised with regard to the maintainability of the writ petition because it was not a public interest litigation. The account was not an aggrieved person. Therefore, this Honorable Court has dismissed that petition on the ground of maintainability. Other day,
It was not dismissed, it was disposed of. I have submitted the order, the last order, final order.
Other day, my learned friend has referred to that judgment. And a categorical observation was made. In this manner, it cannot be filed. So if the petitioners are aggrieved, they can come seeking for specific relief and specific prayer. That was the direction.
Court said if that OM is violated, then court can be approached.
That was on a point that if, because Lordship is well aware, on completion of 3 years of continuous service of ad hoc and contract employees, they can be regularized. There was a notification of his memorandum in that regard. It was not quashed actually.
No, that 3 years memorandum was quashed.
Yes, 3 years memorandum was quashed. Therefore, the single judge said that state government shall not regularize those who have completed only 3 years of continuous service. We have to be careful on that because the OM allows beyond 3 years. But in that litigation, this Honorable Court held that persons who have completed only 3 years cannot be regularized. That means indirectly it can be understood that, okay, then if it is more than 3 years, then those cases can be considered. But that observation was not made. But the specific observation was made that persons who have completed only 3 years of continuous service on a tow contract cannot be regularized on the basis of the OM. That is the clear observation by this Honorable Court. The division bench has also reiterated that observation. So that litigation has come to an end. Second litigation, round of litigation was a combined jumbo-sized writ petition was filed. A person who is MA Economics has challenged the appointment of a person who is MA Political Science. So different subjects were there, but then they have filed a combined writ petition questioning the other subjects where I cannot be qualified also. So it was filed in the individual capacity, but it was not properly filed. Withdrawing that petition, my learned friend has mentioned that due to some subsequent development, this writ petition was withdrawn. But there was no other subsequent development except the point which we have pointed out that, look, this writ petition is not maintainable in the present form. Because all are not accurate. There are different cause of actions in different subjects. Therefore, writ petition cannot be maintainable in this manner. That is what on the earlier litigation also this Honorable Court has made observation. When we pointed out that, they became wiser to withdraw the writ petition.
It was not
And
withdrawn. It
subsequent-
was dismissed, not on merit, and liberty was granted. Why
By
the
granting
courts are
liberty,
here?
by granting liberty,
Always
it
liberty was
withdrawn.
granted.
So, by filing the third writ petition, which is the present series of cases, they have just changed the subject-wise.
Of course, the court directed us.
Subject-wise, court said that in accordance with law only. So now, whether law permits that or not is to be examined by this Honorable Court in this present proceeding. This Honorable Court has never said that you file subject-wise, you file the writ petition in this manner. No. File in accordance with law. Therefore, the present writ petitions are to be examined by this Honorable Court, whether the petitions are filed in accordance with law or not. So that is very important. First thing first, Lordship, these petitions are not public interest litigations. We have to be very careful on this.
The petitioner is allowed to withdraw the writ petition with liberty to file afresh.
Yes, that is how they are filing.
So now they have come.
My learned friend is again having a grievance that, no, it was disposed of, not withdrawn. But it is withdrawn. That is what this Honorable Court order says. Withdrawn with liberty to file afresh.
For clarification, Lordship, that was the last order. That was the last order, and I have annexed.
5723.
Yeah. Here, that was right after we filed the writ petitions. The respondent government issued the last page extension after we filed the writ petition. So, just basing upon that, we withdraw it in order to implement the last extension order. That was it. What is wrong in it? Liberty was granted.
Before that, net qualified forum has filed. That was
Why
also
go up to that?
dismissed
Just plead on merit.
maintainability only.
Yes.
The present writ petitions, what I have understood during the submission and by going through the pleadings, the present series of petitions have been filed, basically basing on the ratio laid down in Umadivi's case and subsequent judgments passed by the Honorable Court, where the Honorable Apex Court has made observation that for public employment, it has to be, the post has to be advertised, and if it is not advertised, then it will amount to violating Article 14 and 16 of the Constitution of India. Now, with regard to the recruitment, coming to the Omadibi's case, the case in Omadibi is a case for regularization of ad hoc contract employees. Lordship is well aware. Thereafter, many cases have been decided. There are some deviation in some cases. Deviation in the sense, some branches have been carved out of the paragraph 53 of Omadibi's judgment. Lordship is well aware about the Bar Association of Pandibara versus the state of Himachal Pradesh, Jammu and Kashmir, sorry. There also, the paragraph 53 has been digested. And in recent judgments, in many judgments in 2004 and 2024 and 2025, with regard to the clipping of hands of the garment has been again, some relaxation has been observed in many judgments that in exigencies of service, garment should not be completely stopped or barred to make appointment for temporary periods, say ad hoc contract, work charge, all these things are there. Here is a case where the career of students are involved. And Lordship is well aware about the conditions in the state, about the post creation and the financial constraint faced by the state. Colleges are upgraded from higher secondary to the full-fledged college, thereafter post-graduation. Creation is not there, creation of post is not there, but upgradations are there. That is considering the needs of the students. Because all students cannot go outside the state and study in good educational institutions. Therefore, there are limitations for the state so far as the financial position is concerned. But then, in view of the public demand, they are expanding the colleges. But then there is no post-creation, because post-creation will involve financial implications. In view of all these problems, the state government was compelled, was constrained to make appointment on temporary basis. The main thrust of the writ petitioner is that even if it is for temporary arrangement, advertisement should have been done, and it was not advertised. Therefore, all our appointments should be quashed, and a direction should be issued to the government to advertise the post. The other day, Lordship has heard the submission of the State Council, the Learned Additional Advocate General, who said that on the basis of the net base, we have appointed, and yes, when there are sanctioned posts, clear sanctioned posts, then yes, we have been making the advertisement and making the recruitment. That was the submission made by the Additional Advocate General. Coming to our case, the ratio which has been laid down by the FX Court and catching up decisions, the facts and circumstances of those cases are totally different from the present case in hand. If the facts are similar and exactly the same, then yes, the ratio laid down in that case can be applied in this case. But then just a principle has been laid down by the Apex Court that should be applied here, although the facts and circumstances are different. By accepting the submission of my learned friend, if any law made by the Supreme Court, passed by the Supreme Court, is to be applied in toto, unprincipled. I will just try to bring one example. A temporary appointment was made in Kerala in the post of assistant professor. That was done without any open advertisement. But the Supreme Court says that any post, even if it is for temporary appointment, it has to be advertised and all the citizens of the country should be afforded opportunity of being heard. Then in such a situation, can a person from Nagaland can challenge that on the ground that since Honorable Supreme Court has laid down a law to advertise the post, even if it is for temporary purpose, it has to be advertised, and if it is not advertised, then it will amount to violation of Article 14 and 16 of the Constitution of India. Can an order be passed like that in such a situation? In our case also it is the same. But therefore, the rulings which my learned friend has cited, that the posts are to be advertised even if the appointment is for temporary, cannot be strictly applied in the given facts and circumstances of this particular case. Now,
but even if it's for temporary appointment,
Lordship,
why should anyone be just picked up?
it is not picked up, Lordship. Some appointments are made on the basis of advertisement.
That advertisement we have seen, so that is okay. Certain people may have been appointed after that advertisement, departmental selection.
Yes.
So that is also fine. Yes. But some of them are appointed without any advertisement, without any selection by the department also.
Yes, some appointments have been made. That is
Yes, it
on
differs
record.
even among the respondents.
I don't deny that.
Yes.
Now come to page 13 and 14 of the petition. I am holding 189 because my case starts with 189. I will rely on this basically. 189 of 2023. '13 and 14. Mr. Lordship, just straight to the point, quash and set aside. And then few notifications are there. These are the appointments of the private respondents. All the notifications. And then come to the next page. Some appointments are after advertisement. Some appointments are not appointment but engagement. Engage. Not appointed but engage. And come to the next page. Direct the respondents. Page 14. To terminate the services of respondent number 5 to 13, who were appointed as assistant professors in political science without due process of law. For engagement on fixed pay of rupees 12,000, what due process happened violated? Let the petitioner also satisfy. D. To requisition the 5 sanctioned posts of assistant professors held by the respondent number 6, 7, 8, 9, and 11 to NPC for advertisement. Government said these are not the sanctioned posts. So under which law a non-sanctioned post can be directed by this Honorable Court to advertise? E. Do advertise 4 sanctioned posts of assistant professors held by respondent number 5, 10, 12, and 13 strictly as per law. Which law governs for engagement or for temporary appointment, but the one that it has to be advertised and it has to be filled up in accordance with law. And then in the interim, they have sought for a blanket order, but then this was not given. And during the course of hearing, the counsel for the writ petitioner has candidly admitted that this case is basically for advertisement. That is what my learned friend has submitted during her submission. Now, there are two things here: to terminate our services and then to advertise the post. That these are the two basic prayers made by the petitioner. Now, firstly, to terminate the services of the petitioners, of the respondents. First thing first, who are the petitioners? Who is he to question this? Whether he has the locus standi or not. I am furnishing a chart. I have arranged it case-wise. All the cases, the position of respondent, date of qualifying date, date of appointment. On the date of appointment, except two persons, all the petitioners in all the petitions did not possess the qualification of NET at the time of appointment of the private respondents. So, may I go case by case, Lordship? Let us go to the first.
None of the petitioners.
Here, one. Petitioner number 1, Achem Ngoli. But I will come in detail. Let us confine to first page, WPC 189 of 2023. This petition is pertaining to political science subject. I am representing respondent number 8, 9, 10, 12, and 13. And all these posts are non-sanctioned posts. And then respondent number 6 in this petition, he has been appointed on the basis of advertisement. The writ petitioner has not mentioned in their petition that the respondent number 6 has been appointed, engaged on the basis of an open advertisement. And that advertisement was on the basis of an order, a policy decision of the government, not the department. The order was issued by the Commissioner and Secretary for advertising the post. So it is a policy of the government. And then after the interview, we were engaged, not appointed, engaged with a fixed pay of 12,000 rupees. Imagine, Lordship, it is not the salary of even a chowkidar or bureaucrat for employee in the state. But fortunately, it was enhanced to 20,000. At present, they are trying a salary of 30,000, fixed pay of 30,000. An assistant professor in a college is trying a bare maker amount of 30,000 only. That is less than beyond a chowkidar in the central government employees. But then that is the state of affairs. And for your Lordship's information, the economics department in the Science College is all run by contract appointees. The HOD is also a contract appointee, and all other faculty members are contract appointees. Suppose tomorrow, if the state government take a decision that we will not give any longer the contract appointees, that the entire department will be no faculty members. That is the situation. Under such trying situation, the state government was compelled to engage on temporary basis. Of course, fortunately or unfortunately, it continued little longer than they expected, I should say. Now, see the particulars of the petitioners and the respondent. On the extreme right, date of appointment is shown, except the last one. All are appointed prior to 6/6/2016. Top are the respondents, and down below
only this
serial number 6, last one is appointed on 23/11/2016. That is after 6/6/2016. Lordship is aware about the appointment and ban on appointment. And then the second column, Lordship will find the serial number of the petitioners, petitioner number 1 and 2, and the extreme right, date of qualifying need. Serial number 1, Achem Ngoli. He obtained net on 10/11/2014. So, after 4 respondents were appointed, after that only he obtained net. In other words, at the time of appointment of 4 respondents, the petitioner number 1 did not possess the qualification of net so as to question our appointment. Petitioner number 2, Lano Yangla, she obtained B.Ed only on 31/7/2018. Therefore, on the day when we were appointed, she was not even eligible. Now the question is whether an eligible person who do not possess the requisite qualification can question and come before this honorable court to quash the appointment of somebody who were appointed before she could be eligible, even for those posts. Coming to Achimngoli also, at best, he can question about respondent number 12 and 13, who were appointed after he was eligible. Other than this Achimngoli and another petitioner in another case, all others who has filed the writ petitions were not eligible at the time when the private respondents were appointed. And if Achimngoli wants to challenge, at best, he can challenge only in respect of 2 persons.
Respondent 12 and 13.
Yes, because by the time this respondent number 12 and 13 were appointed, Achimngoli has already obtained net qualification. Otherwise, but I'm questioning, who is Achimngoli to question these other four respondents who were already appointed before he was eligible? I would like to set an illustration on this point. I'm questioning the process of a selection. I should have been appointed instead of so-and-so, like that. But in order to question that, first, I should be eligible to apply for the post. Only when I'm eligible to apply for the post, then only I acquire a right to question about the selection process. But I'm not eligible even to apply for the post. Where is the questioning about the selection process? When I'm not qualified and eligible, it is same as that. Who is Achimngoli to question the appointment of 4 respondents when he was not possessing the requisite qualification? But they have challenged. They have challenged. I'm questioning his status. Therefore, Achem Ngoli did not have the locus standi to question the appointment of 4 respondents. So with all these discrepancies, whether this Honorable Court can issue a direction to interfere with the appointment order of the 4 respondents, for that matter, all the respondents. And as I have submitted, Lanoyang La, she was not possessing the requisite qualification when all of us were appointed. Therefore, Lanoyang La did not have the locus standi to question of all the respondents. The cause of action in respect of different individuals are different. I think that will make the position clear in respect of 189.
Okay.
I have to trouble your lordship to switch over from one writ petition to another writ petition, but it is better to go systematically so that there can be no confusion. Kindly come to the next page, that is WPC number 190 of 2023. Here, this writ petition pertains to English. There are 2 petitioners here.
In 190, there are 2 petitioners.
Yes, there are 2 petitioners. Out of the 2 petitioners, both were not eligible at the time of our appointment. Because all were appointed prior to their NET qualification. But fortunately, the petitioner number 1, Rite T. Mero, she appeared in NPSC in 2024 and she got
You're
selected.
coming to WP 190.
Yes. Lordship is on that. WP 190 of 2023. Subject is English. I am representing respondent number 5, 8 and 10. So in the chart, the post held by respondent number 5, 8 and 10 are non-sanctioned posts. The year of qualifying NET is 2007, 2012, 2018. And the date of appointment is 2008, 2014, 2017. So these 3 respondents obtained NET as well as appointed as assistant professors before the petitioners obtained NET. So both the petitioners were not eligible at the time of appointment of the private respondents, because both of them obtained NET in 2019 only. And all appointments of the private respondents were prior to 2019. Therefore, a non-eligible and non-qualified person.
In your chart, you have only shown this petitioner number 2. So
Yes.
both petitioner 1 and 2 qualified NET in 2019.
Yes, but she is no longer a party here now, because on selection by the NPSC, she has been deleted as the petitioner. So only Sovilu Vino,
Only this Sovilu Vino.
petitioner number 2 remains, and she obtained NET on 5/1/2019. So she became eligible to question our appointment only in 2019. that time the appointments were already done. So in such a situation, whether the petitioner will have the locus standi to question which was done prior to her eligibility. She did not have the locus standi to question.
Yes.
In 189, I have forgotten one thing, one important thing. Serial number 1, Donald Tufi. He was appointed on the basis of advertisement. That was not brought to the notice by the petitioner also. And they are saying that without advertisement. But this was after advertisement, this appointment. Serial number 1, respondent number 6. I believe I'm clear on 190.
Yes.
Then let us go to 191. There is one petitioner here only, and she obtained net on 12/7/2019. And all the respondents were appointed before she obtained net. Therefore, she do not have the locus standi to question Lordship.
192.
Yes. Can I go to the next petition, Lordship?
Yes.
WPC 192/2023. Subject is philosophy, and I am representing respondent number 8, who is holding a non-sanctioned post. And there are 2 petitioners here. Both the petitioners were not eligible when the respondent number 8 was appointed on 15/3/2016. Therefore, both the petitioners do not have the locus standi to question the appointment of respondent number 8. Next, WPC number 194 of 2023. It pertains to economic subject. I am representing respondent number 7, 8, 11, 12, 14, 15, and 16, who are holding non-sanctioned posts. And out of 9 respondents, 2 respondents, that is serial number 5 and 6, Shri Thamjan Maran and Shri Choba Khamsak. They were qualified net in 2007 and 2010 respectively, and appointed on the basis of an advertisement on 30/10/2011. The date of appointment is same because same advertisement, and it was an open advertisement, and these 2 were appointed. So the ratio which my learned friend has brought that, even if it is for temporary period, it should be advertised. And it is not advertised, therefore it should be interfered. But my submission is, it is advertised. Therefore, the appointment should not be interfered. Petitioner fails there. And petitioner has not distinguished this also. Actually, they should come with a clean hand that, look, we are questioning this. These people were appointed on the basis of a selection, but we are challenging it to not that. So, blindly they have fired. If it hit the target, very lucky. If not, then it's okay. Something like that. So, any person who is approaching this honorable court with an unclean hand and unclean heart, that should be dismissed. That should not be allowed. And the petitioner has approached this honorable court without clean hands, without clean heart.
Here also petitioners obtain net after your appointment.
All appointments were done prior to the obtained net. Petitioner number 1 obtained net on 31st December 2019. Nitu U. Mero obtained P8 on 31/7/2018. In respect of 1, it is last serial number 9, respondent number 16, 27/9/2018. He was engaged, not appointed. And petitioner number 2 obtained net on 31/7/2018. But at least Thangmong was not eligible. Even in respect of respondent number 16. Otherwise, all other respondents, they were already appointed. Therefore,
but some of the respondents are appointed after 6/6/2016.
Yes, here 3 of them were appointed after 6/6/2016. That is respondent number 14, 15, and 16. These are from record, so I cannot deny that, Lordship. So at least Nityu U. Mero, petitioner number 2, if she has a grievance, she has a grievance in respect of P. Emna Wapang, who obtained net only on 27/9/2018, and not Thangmong. Therefore, different cause of actions are there. So cannot be dealt in one petition only. So therefore, a writ petition is defective, like before. Nothing different, same. And some are, respondent number 5 and 6 were appointed on the basis of advertisement, selection, open advertisement. May I go to the next case?
Very confusing for the court also. No. See, Ms. Imomi, so many categories are there. It is very confusing for the court also. Some of the respondents appointed after advertisement, some of them were appointed after 6/6/2016, some of them were appointed before that.
My lord, to me, solution is very easy.
Lordship.
The writ petition is defective, so it should be dismissed outrightly.
How, Lordship, I pray before this honorable court, what the learned senior advocate is submitting before this honorable court is, had they been appointed after the advertisement, we have no locus standi to challenge their appointment when they were appointed. But this is a case where they were appointed with illegally. And in any illegal appointment...
No, some of them were appointed after advertisement.
Advertisement is there, but Lordship, I have already point before this honorable court the other day, it was the advertisement is August 2011. Now, pending regular recruitment through NPSC, the Department of... These are their conditions. So how long?
There was an advertisement. The issue is whether there was an advertisement or not.
Whether there was advertisement or not. So advertisement was there.
I leave it to your
How
lordships.
long they should continue, it is the prerogative of the government.
No, contract appointment cannot go on lifetime. This is not in my interest or any other, but it is interest of the whole. Then, if what they are saying is legal before this Honorable Court, Lordship.
And at that time, at the time of advertisement, whether you applied or not, that is also one question. Even if it's for temporary.
Lordship.
Yes, anyway, please continue.
Even non-advertisement of the post, we are agreed. Had there been frequent advertisement, then we could have been selected by now, and then we could have been in the regular service.
If it is a legal appointment, we have no locus. But when the appointment is void ab initio, they have no substantive right to plead before this Honorable Court. We cannot challenge it. In general, if that be the case, Lordship.
No, but at that point of time when you were appointed, if you were not qualified, then.
Yes, we are not qualified. But here is a question of we challenging the illegal appointment.
It is
Lordship.
not a public interest litigation. That is why.
It's illegal appointment. And there are so many Supreme Court cases, Lordship, if my Lord will, on that point where the learned senior advocate is submitting before this Honorable Court, and if this Honorable Court feels that what submission of that we have no qualification at the time when they were appointed through backdoor, who has the locus, just tell the court, submit before this Honorable Court, who has the locus to challenge the backdoor appointment? That is what they have to plead before this Honorable Court.
To question the illegal appointment?
Now,
you are saying that it is illegal. To show that, to challenge that, you should have first the locus standi.
Lordship.
You can reply.
Who has the locus? Let them show before this Honorable Court.
That is why in the initial stage of my submission, I was saying, first thing first, if it is illegal action, then out of that action, they want to benefit by approaching this Honorable Court. But to interfere with that, first you should show that you have the locus standi to question this. First, you should have the locus standi to question whatever may be the action. It is not a public interest litigation. Had it been a public interest litigation, yes. But then it is not a public interest litigation. Let me come to writ petition 196 of 2023. This is pertaining to subject of sociology. I am representing respondent number 7, 11, 12, 14, 17, and 18. And all of us are holding non-sanctioned posts. And out of these respondents, the respondent number 15 has been deputed from economics and statistics. Who is respondent number 15? Deputation from economics and statistics on 28/2013.
Economics and Statistics Department.
She has not been observed yet. So this is also a separate case. Petitioner could not have included this.
On deputation from Department of Economics and Statistics.
Yes. On 28/2013.
28/2013.
And the writ petitioner, there is only one writ petitioner here, obtained it only on 2nd January 2018. Therefore, at the time of appointment of all the respondents here, writ petitioner was not possessing the requisite qualification of NET so as to question and so as to apply for the post also. Therefore, she do not have the locus standi to question the appointment of 7 respondents. And this could have been projected by the petitioner clearly that so-and-so has been brought into petition, but then in a wholesale manner that appointed without selection and all that. not the vector. The so-called nomenclature.
Deputed on 28/2013 and still continuing on deputation.
Yes. Can we switch over to the next?
Yes. 197.
197. Subject is geography. I am representing respondent number 5 and 6, holding a non-sanctioned post.
Just come back.
I'm asking them today why I'm sitting Glasgow. So I can tell my about that. It's to me.
Sir, আপনি তো কিবা লগা তো ক'ত এডভাৰটাইজমেণ্ট আছে কোৱাচোন
23. It pertains to the geography subject. I'm representing respondent number 5 and 6, holding non-sanctioned post. And then here, only one is qualified to question the appointment of the respondent number 5 and 6. Petitioner number 2 has obtained net only on 5/1/2019. Therefore, she do not have the locus standi to question the appointment of respondent number 5 and 6. The last case is WPC 198 of 2023 pertaining to Education Department. I am representing respondent number 5, 8, 11, and 15. We are all holding non-sanctioned post. Of course, the respondent number 9 is holding a sanctioned post, Lordship. Lordship will find from the chart that all appointments were made up to 2016, 2012, 2014, 2016. All appointments are prior to 6/6/2016. And the vacancy, if we look at the vacancy, they are all adjusted in temporary post, temporary appointments. And Lordship may see the status of the petitioners. There are 2 longcomers. I believe they are not sisters. Date of qualifying date is 31/12/2019, 31/12/2019. So both of them were not eligible to question the appointment of all the respondents. Therefore, Lordship, there are lots of discrepancies. In each and every petition, there are discrepancies. With so much of discrepancies, whether an effective order can be passed by this Honorable Court. That too, there are cases where appointments are made after due advertisement. Some are brought into petition and still into petition. But the manner of constructing the writ petition was all appointments and engagements were made without selection process and we are deprived. So what grievance, what injury the petitioners have sustained for appointment of the respondents before they were eligible to apply for the post? It is very clear that petitioners were not eligible except 2 when we were appointed. And therefore, they do not have the locus standi to question our appointment. And with so much of discrepancies, whether this Honorable Court can enter into all this and pass an effective order. The petitioners on the earlier occasions have approached this Honorable Court in the same manner, and this Honorable Court has not interfered with the appointment of the private respondents. Rather, petitions were disposed of with granting liberty to file afresh because it was defective and it was very difficult for this Honorable Court to pass orders. And in the present petitions, they have committed the same mistake. There is no difference, same mistake. Only difference they have tried to make out is that they have made different subjects, separate petitions. Only that much. Otherwise, it is as good as the earlier petitions, where they don't deserve to get even a relief from this Honorable Court. Now, second point is with regard to the second part of the prayer is they have sought a direction to the government to advertise the post. Lordship is whether this Honorable Court can direct the government to fill up the post or not to fill up the post, or to advertise or not to advertise. And more particularly, in the present case, when the posts are non-sanctioned posts, then whether a non-sanctioned post can be directed to issue an advertisement and fill up the post. And filling up the post and not filling up the post is the prerogative of the state government. So in my respectful submission, Lordship, this Honorable Court cannot issue a mandamus directing the state respondents to advertise the post or to fill up the post, because to issue a direction is to fill up the post. So government knows in their wisdom that what are the sanctioned posts, whether it is possible or not, all this will come. Another very important aspect which Lordship may not ignore is with regard to the filing of the writ petition after so much of delay. As Lordship has seen, since 2010-11, there were expansion, there were date also, there are some cases where the appointments were made arising out of the date of the serving lecturers, like that. Now, even if the teacher dies, the students will not automatically die. The classroom will not be vanished. Classes has to run. Education has to be imparted, for which teachers are required. Therefore, on the need-based, the petitioners were engaged. And why they were engaged? The Learned Additional Advocate General has submitted yesterday that on the need-based, we have engaged. And accreditations were there, and frequent transfers of teachers. In some cases, the replacements were not sent. There is demand from the different organizations. Nagas are very popular of forming different organizations, union, and making demands one after the other from the state government. All these are there. So government is also cornered in a way to make appointment. So Lordship is well aware about the process of an advertisement, how much cost it will involve, and what are the process involved in the rubber advertisement.
But
Financial
some of the
constraint.
respondents are holding sanctioned posts also.
One or two stray cases. Now, with regard to the delay, Lordship, kindly examine. They have filed a writ petition in 2023, challenging our appointment made sometime in 2011, 2012, 2013, 2014. Only few cases are after 6/6/2016. All are prior to that. Even otherwise, under normal procedure under the government, we deserve to be regularized also. And by now, all of us have become over age also. Most of us are over age. And then, even to face a competitive exam also, it will be difficult. If I compete with a free student now, I will not be able to compete with them. In the process of argument, I can make many arguments and submissions, but then to face a competitive exam, I will not be able to compete with fresh graduates, Lordships. There is inordinate and unexplained delay in filing the writ petition, questioning the appointment of the private respondents. I will conclude by citing a decision on the issue of locus standi. I will refer only one judgment, 2013, 4 ECC, 456. I have just printed it out. On the issue of locus standi and the person aggrieved and maintainability. So, few paragraphs. Lordship can note down the paragraphs.
Yes.
Paragraph 9, 10, 12, 19, 20, and 23. I may be allowed to read these paragraphs and I will conclude my submission. Paragraph 9, Lordship will find it page 475.
Person aggrieved.
Yes. Only when they are aggrieved, then they can approach the Honorable Court. It is a settled legal preposition that a stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority or court that he falls within the category of aggrieved persons. Only a person who has suffered or suffered from legal injury can challenge the actions, order, etc. in the court of law. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the appellant that there has been a breach of statutory duty on the part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which writ jurisdiction is resorted to. The court can, of course, enforce the performance of a statutory duty by a public body using its writ jurisdiction at the behest of a person, provided that such person satisfies the court that he has a legal right to insist on such performances. The existence of such right is a condition precedent for invoking the writ jurisdiction of the courts. It is implicit in the exercise of such extraordinary jurisdiction that the relief prayed for must be one to enforce a legal right. In fact, the existence of such right is the foundation of the exercise of the said jurisdiction by the court. The legal right that can be enforced must ordinarily be the right of the appellant himself, who complains of infraction of such right and approaches the court for relief as regards the same. By so-and-so, all judgments have been referred to. Paragraph 10. A legal right means an entitlement arising out of legal rules. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from a psychological or imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. Clearly mentioned in the judgment. 12. In Subhas Babu versus State of AP, this court held, the expression aggrieved person denotes an elastic and an elusive concept. It cannot be confined within the bounds of a rigid, exact, and comprehensive definition. Its scope and meaning depends on diverse variable factors, such as the content and intent of the statute, of which the contravention is alleged, the specific circumstances of the case, the nature and extent of the complainant's interest, and the nature and the extent of the prejudice or injury suffered by the complainant. See, very clearly, I need not explain. In a lawsuit terms, very clearly it is mentioned. And imagine the case and the facts involved in our case. What grievance? How they are aggrieved? That should be made very, very clear. And the Honorable Apex Court has said very clearly, paragraph 19, page 478. Paragraph 19. The court in Ravi Yashwant Parapress's District Collector Rakhikat held as under. Shri Chintaman Rakhunath Kharat, ex-president, was the complainant. Thus, at the most, he could lead evidences as a witness. He could not claim the status of an adversarial litigant. The complainant cannot be the party to the lease. A legal right is an averment of entitlement arising out of law. In fact, it is a benefit conferred upon a person by the rule of law. Thus, a person who suffers from legal injury can only challenge the act or omission. There may be some harm or loss that may not be wrongful in the eye of law because it may not result in injury to a legal right or legally protected interest of the complainant. But juridically, harm of this description is called. The complainant has to establish that he has been deprived of or denied of a legal right and he has sustained injury to any legally protected interest. In case he has no legal basis for a justifiable claim to hang on, he cannot be heard as a party in a lease. A fanciful or sentimental grievances may not be sufficient to confer a locus standi to sue upon an individual. There must be injuria or a legal grievance which can be appreciated and not a stat pro ration voluntas reason, claim devotes of reasons. Under the graph of being a necessary party, a person cannot be permitted to make a case as that of general public interest. A person having a remote interest cannot be permitted to become a party in the list, as the person who wants to become a party in a list has to establish that he has a proprietary right which has been or is threatened to be violated for the reason that a legal injury creates a remedial right in the injured person. A person cannot be heard as a party unless he answers the description of aggrieved party. So rulings are very, very clear that in the present case, they are like strangers. And paragraph 20 is very, very relevant in our case. Paragraph 20. A similar view has been reiterated by this court in K. Majushree versus State of AP, wherein it was held that the applicant before the High Court could not challenge the appointment of a person as he was in no way aggrieved, for she herself could not have been selected by adopting either method. Moreover, the appointment cannot be challenged at the belated stage, and hence the petition should have been rejected by the High Court on the grounds of delay and non-maintainability alone. So, when all these points are involved, on the ground of non-maintainability, the writ petition is to be dismissed. Here in our case, delay is also there, and it is not maintainable because the writ petition is defective, and there are separate cause of action. In one writ petition, only this cannot be cured. Paragraph 23. This is the last paragraph I'm referring. Paragraph 23. Thus, from the above, it is evident that under ordinary circumstances, a third person having no concern with the case at hand cannot claim to have any locus standi to raise any grievance whatsoever. However, in exceptional circumstances as referred to above, if the actual person aggrieved because of ignorance, illiteracy, inarticulations, or poverty are unable to approach the court, and a person who has no personal agenda or object in relation to which he can claim his own acts approaches the court, then the court may examine the issue and exceptional circumstances, even if his bona fides are doubted. But the issue raised by him, in the opinion of the court, requires consideration. The court may proceed so motu in such respects. Here is a case where the petition has been filed by a person who are highly qualified people, and they are not illiterate persons, so as to get a different treatment. to conclude, I would like to refer to a paragraph which Supreme Court has said about the status of the academicians and lecturers. It was passed in 2025 on August 22nd, 2025. Recent judgment, 2 months before. Academicians, lecturers, and professors are the intellectual backbone of any nation, as they dedicate their lives to shaping the minds and character of future generations. Their work goes far beyond delivering lessons. It involves mentoring, guiding research, nurturing critical thinking, and instilling values that contribute to the progress of society. However, in many contexts, the compensation and recognition extended to them do not truly reflect the significance of their contributions. When educators are not treated with dignity or offered respectable emoluments, it diminishes the value of the country, places on knowledge, and undermines the motivation of those entrusted with building its intellectual capital. By ensuring fair remuneration and dignified treatment, we affirm the importance of their role and reinforce the nation's commitment to quality education, innovation, and a brighter future for its youth. So, all the teachers are sacrificing their time, energy for the welfare and development of the entire country. They are molding the future generation of our country. And with so much of sacrifice, it is very, very unfortunate that they are getting a maker salary of 30,000 per month. Just imagine, even in Kohima also, it may not be even the fare for the cost of fuel from down to the college. So under such circumstances, the respondents are working. And petitioners who has filed a writ petition challenging the appointment of the private respondents, they do not have the local standard of question, and there is unexplained and inordinate delay in filing the writ petition. Petition do not have any merit. Therefore, the writ petitions are liable to be dismissed. I conclude my submission, Lord. Highly obliged, Lord.
May it please your Lordship.
Yes. You are in?
I am also selectively in all the other petitions.
Okay.
So I have, prior here too, I have supplied a list of respondents which I am representing, but I would like to submit again, just for clarity. Now, my learned senior friend representing the other respondents have more or less covered the submissions which I would also be making in all these petitions.
No, which one should we rely on first? 189? 188.
Now, I'm also taking two preliminary objections on the maintainability of the petition. First, on the locus standi, which is also analogous to the second ground which I'm taking is the delay in latches. Now, since my learned senior friend had already made the necessary submissions, I will not be wasting the time of the court in dwelling into all those legal submissions. But for my own benefit, allow me to, and for the court's benefit, allow me to take a lordship to the facts as has been narrated in my counter affidavits. Now, if your lordship may kindly have WP 188.
Seven, 8, 10, and 11.
7, 8, 10, and 11, yes. Now, in all the counter affidavits, filed by the respondents, the petitioners have not bothered to file any affidavit in reply. So the contentions which have been made in the counter affidavits, including that of the state, has remained uncontroverted, and it can be deemed to be taken as being correct what have been averred in the counter affidavits. Now the first ground, if your lordship may have page 3 of my affidavit.
Yes, page 3.
Yes, at paragraph 4. Now here in this petition, the petition number 2. Now similar with the petitioners in the other petitions. Now there are only 2 persons who had qualified, who had cleared their NAD exam prior to the appointments of the respondents. 95% of the counter affidavits, or 95% of the cases, none of the petitioners have cleared NAD when the respondents were appointed. I would just like to quickly take a lordship through all those. Unfortunately, I have not been able to prepare a table in the manner as it's been prepared by my learned senior friend, so I would just like to rely on the affidavits.
That was very convenient. Yes.
Yes. If your lordship requires, I can prepare also.
You can prepare and submit
Very
after
well.
the hearing.
Yes.
Also.
Now, in
fact,
this
I
petition,
think all the respondents can prepare the table.
can do that. In this petition number 2 cleared her NAD in 2019. Now I have made a categorical statement stating that the respondents, they were appointed in 2016, 2018. Now therefore, the moot question, which in other words, as has been raised by my learned senior friend, is the moot question is whether the petitioners can, after the respondents have been appointed, get their qualifications, come back and challenge the appointment of the respondents. That's a moot question insofar as the locus is concerned. 2016, 2018, and in the next page, the analogous, which is analogous to my first ground, that is the ground of delay and laches. Allow me to just read out. Thirdly, the deponent submits that this petition miserably suffers from delay and laches. Insofar as the respondent number 7 and 8 are concerned, there is a delay of 7 years in challenging their common appointment order dated 14/7/2016. Similarly, there is a delay of 5 years in challenging the appointment orders of respondent number 10 and 11 who were appointed on 7/8/2018. No explanation has been set forth in the petition as to why the petitioner is approaching only now with a fanciful, disillusioned, and completely misplaced grievance. Therefore, as well, this incident petition is not maintainable. Now, similarly, in all my counter affidavits, I have taken these 2 grounds.
Locus and then the delay.
Yes, on the leg of locus standi and delay and laches. Now, in view of that, allow me to just quickly. Your Lordship, while I'm at 188, I would also like to advance a contention on merit to the effect that the appointments of the respondents are not illegal, neither are they backdoor. Now, in view of that, since I'm at 188, allow me to just take your Lordship to certain annexures which I have enclosed, as to how and in what manner appointments have been made. Now, these are just instances, just to show the general nature in which the department is including the departments in the colleges. They have been requesting the government to make appointments. Now, at page 12 of my counter affidavit, this pertains to the commerce subject at Kohima College. This was written by the principal. Allow me to just read the contents. On the above mentioned subject, I have the honor to state that the following lines for your kind immediate action to avoid any resentment from the students' community. That, sir, as approved by the State Education Board and verbal assurance given by Parliamentary Secretary, Higher and Technical Education, to introduce Sociology discipline and Commerce stream from June academic session 2016 at Kohima College, Kohima, the college has accordingly projected a new discipline and stream in the prospectus/admission forms and has admitted the students accordingly. However, till date, no faculty or staff for Sociology and Commerce stream has been appointed, and regular classes for this academic session is due to commence from 13 June 2016. I therefore request your benign authority to expedite the appointment process without further delay. Now, subsequent thereto, a meeting was held at page 13. And this was attended by the then Parliamentary Secretary at clause 2. The following decisions were arrived at after thorough deliberation on the interim engagement of teachers for sociology, psychology, and commerce. Now at clause C. Selection shall be made through a suitability test, which shall be conducted on 1st July 2016 in a conference hall of the Directorate of Higher Education, so and so, so and so. And then clause 5, 6, 7, these are the certain criteria which they mentioned in this meeting. Pursuant to this, some of the respondents have been appointed. Now, I have not, the appointment orders are already enclosed in the petition, so I have not enclosed. Yes, Your Lordship, may I kindly have the petition 188, page 37. A notice was published, and page 37.
37?
37.
Yes.
Yes. This followed the meeting of which I just read out.
Okay.
And these are the appointees. Now the respondent 7 is under commerce subject at serial number 1, and the respondent 8 is at serial number 2. Now this is just to highlight an instance of how appointments have been made in exigency to fulfill the requirements. Now, another instance I've also enclosed at page 14 of my counter affidavit.
Page 14.
Page 14 of my counter. This pertains to respondent number 7. Now this, again, is an application from the director. Of course, it was preceded by the application from the principal. That is how they have been processing the extensions. Now at paragraph 2, if the Lordship may notice, Srimati so-and-so, the respondent 7, is appointed on exigency need basis due to introduction of new stream of Kohima College. There are only 3 teachers in the department and her service is required for the smooth functioning of classes. Now, the reason may be terse, but it shows the requirement and it shows how on exigency basis the appointments have been continued. Again, this is just another instance. I have not been able to collect everything, but this is the manner in which the department as well as the colleges, they have been requesting the department to kindly continue with the appointments, the service of the contract teachers so that the classes are not affected. In the same manner, I've also enclosed another extension application at page 15 pertaining to the same respondent for another year. In similar manner, in all my counter affidavits, I've enclosed all the instances where the appointments have been made and where their appointments have been continued on exigency basis. I will not be referring to all those, but if Your Lordship may kindly have WP 189. I'm representing 5, 7, and 11. Here also at page 3 of my counter. It's the same case. There was a...
Page 3.
Yes, page 3, paragraph 4. They obtained their qualification only after we were appointed, 4 or 5 years. In some cases, even 10 years. only after getting their net qualification, they came to challenge the appointments which were made in 2010, 13 and 15. Again, this has remained uncontroverted. If you let me, can you take note of that also?
2010, 2013.
And in that view, I'm also contending that there is a gross delay and laches in filing the instant petition, and they are not maintainable on these grounds. Now, in this affidavit as well, at page 12, sorry, at page 12 of my counter, again, another extension application submitted by the college itself to the government. I will not be reading out the contents, but this pertains to Respondent 5 for the subject of political science. The reasons in detail, they have highlighted why they need her services to be continued. And pursuant thereof, this was in 2010, pursuant thereof, her service was continued. Now it's still continuing. Now, again, if your lordship may note that in many of the cases, all the contractual assistant professors, they've been continuing in service for more than 10, 15 years. Now, that may also be taken note of. On merit, I would also like to supplement my submission with certain tax court decisions which is now striking a balance between the jurisprudence laid down in Uma Devi and how the court should apply the case of Uma Devi. And then the next is 190. Here, again, in this case, it shows 190. This is another classic example of how the petitioners have filed these petitions in a very defective manner, in a shoddy manner, without even exercising due diligence as to which appointment they are challenging. Now, in this case, I'm representing 6, 7, 9, and 11. 6, 7, 9, 11. I filed a separate counter affidavit for respondent number 6.
Yes.
In this case, insofar as this respondent number 6 is concerned, what has been impugned in the petition is at page 38 of the petition. This
Page 38.
yes, page 38.
Yes.
This is an appointment order dated 30th of April 2013. The respondents of 6.
This is respondent 6.
Yes, R6 as assistant professor in English at Mount T College. Now this has been impugned, but your lordship will note that the respondent 6 is not continuing in this college anymore. Initially, I have to go back and forth to my counter and the petitions. My apologies. Now, at page 8 of my counter, I've clarified this position.
Counter of R6.
Yes, R6, page 8. This was her first initial appointment as on contract as lecturer in English. Page 8.
Okay.
Dated the 7th of September 2010. Yes, in the subject English at Nagaland College of Teachers Education. Again, the terms and conditions remains more or less the same in all the cases on a fixed pay, unsanctioned post. And thereafter, she was appointed in the impugned appointment order at Mount TE, which
But your appointment
Yes.
on 7/9/2010 is
Yes.
against sanction post.
Yes, but this was subsequently, it was advertised.
Advertised.
Yes. Thereafter, I was appointed at Mount T, which I've just shown you, Lordship.
Then after that,
After that, in 2015, at page 9, I was again appointed back in the State College of Teachers Education, 2015. Now, this notification has not been impugned in the present petition. Now, in certain notifications or the appointment orders, this phrase at clause 2 of this notification, the appointment is made against the post held by Dr. So-and-so who is holding the post. Now, this, in view of the exigency manner in which the appointment has been made, now these are reflected. But in the state's affidavit, this is supplemented, and I'll show you through my affidavits how initially they were appointed, yes, to a vacant post, more or less, but not technically to a post. It's to fill up the vacant post, and thereafter the posts were requisitioned, which has been supplemented by the state's affidavit, and thereafter only, in view of the need for the assistant professors, their service has been continued. This is the trend in which the department is proceeding. In the state's affidavit, I'll make that clear for you, Lordship. Now, so in this R6, the appointment is not challenged. Now for R7, 9, and 11, a consolidated affidavit has been filed. Same grounds I've raised at the counter for R7, 9, 11. Your Lordship has it?
Yes.
Okay, page 3. Here also, the petitioners, they qualified NAD only in 2019, whereas the respondents were appointed way back in 2013, 16, and 17. Therefore, the lack of locus as well, coupled with the delay. Now, pursuant to the filing of the counter, the respondent 9 has resigned from service. I've been informed, even though I have not been able to procure the resignation as well as the order, she has resigned from service. Just to make that point. Now, Your Lordship may have the next petition. (191). Here I'm representing only R5. 191. And he also belongs to the batch of appointees whose appointment was preceded by an advertisement, which Your Lordship has already referred to.
here you're appearing for
R5. Now, similar ground I'm raising. In this case, again, there's a delay of 12 years in my counter affidavit, I've stated. Lordship has found it.
I'm unable to trace it. Because I just see for R5 affidavit here. Affidavit of R5. Anyway, just give me the para numbers here.
Paragraph 3 and 4.
3 and
3 and 4. The respondent 5 was appointed in 2011. Sole petitioner cleared her net only in 2019. Yes, sir. But again, a mindless contention has been advanced to the effect that there was no advertisement. But then in this case also there's an advertisement which your Lordship had referred to earlier, which I've enclosed in my affidavit at page 10.
Page 10.
Page 10, yes. This is the same advertisement which my learned senior friend has also referred to. And just to recapitulate, the appointment order, the common appointment order of all these respondents who were appointed pursuant to this advertisement is at page 34 in the petition.
This is in pursuance of this
Yes,
advertisement.
in pursuant of this advertisement. And I appear at serial number 11 in the next page, 35. Now the next will be WP 193.
WP 193.
Here, only respondent 5.
Respondent
5. Now in my counter at page 3, paragraph 4 and 5, on the ground of locus as well as delay. In the case of this respondent who was appointed in 2017, the petitioners cleared their net only in 2021. And in regard to her extension, your Lordship may also note that it also shows again another the glaring state of affair at page 10. The state of affair already highlighted by my learned senior friend. Now, this was an extension forwarded for the respondent, forwarded by the director to the government. Again, at the last three, just the last 3 lines, the applicant, starting from the applicant has cleared net, She was appointed on fixed pay without post. Her service is required since she is the lone teacher for environmental science. Again, I've enclosed this annexure to highlight an instance of how the colleges are operating in our state. Now the next petition, 194. Again, in this I'm representing 9, 10, and 13.
Yes.
At page 3, similar ground, the same, more or less the same nature. Petitioners, two petitioners here, they cleared the net only in 2019 and 2018. And the respondents, they were appointed in 2014 and 2015. Again, on the ground of delay, no explanation has been forwarded. And in similar manner, I've also enclosed one annexure just to show before this court the state of affair at page 11, which written by the principal, again it highlights the acute shortage of teachers, and that's why they require the services of the assistant professors to be continued. And the next, 195. I'm representing 5, 6, 7, and 8. 5, 6, 7, 8. Now, this will also highlight the manner in which this petition has been filed. It should, to my humble submission, this should shock the conscience of this court, because one of the petitioners was a student was a student of one of the respondents whose appointment is being challenged. Now, again, my counter has not been controverted. In my counter at page 3, paragraph 4. In addition to the ground of delay, as well as the lack of locus, the petitioner number 1, he is a student when the respondent 5 was teaching him an undergraduate course in Kohima Science College. I've made a categorical statement to this effect, that what is starker is the fact that the petitioner number 1 was an undergraduate student of the respondent 5 during the year 2012 and 13 at Kohima Science College. Now, if your lordship take this account into context, then the ground of lack of locus standi, all these petitions have to be dismissed on this ground alone. Without saying much, I would just also like to, I've also enclosed, but I will not be referring to the extension applications as to highlight how, even in our premier Kohima Science College, how the deficiency of lectures are there, and how the departments continuously keep on requesting the government to extend the services of these assistant professors. Now, for no fault of the respondents, therefore, for no fault of them, their services cannot be terminated in the manner as been filed in these petitions. That is one of the grounds on merit I will be submitting later on. Your Lordship, I can continue after the lunch break.
Yes. We'll continue at 2 then.
Very well.
We were on 195.
Yes, Your Lordship, if I may be permitted to continue with my submission from, it would be 196. Yes. Again,
196. WP 196, Koza.
similar ground.
Wherefore,
I am for respondent number 6, 8, 13, and 16. Here in this petition as well, the sole petitioner cleared her net only in the year 2018, while the at page 3 of my counter.
page 3, para.
Para 4. Again, I specifically avert that the petitioner cleared her net only in 2018, while the respondents I'm representing, they were appointed in the years 2014, 16, and 17. Now, in this affidavit as well, I have enclosed at page 14 certain documents just to highlight before this court how the, again, all over the entire state, the government colleges, how they have been requesting the department to extend the services of these assistant contract professors, not at the mere asking, but only on at the request of the principals, the HODs, initiated by the HODs of the concerned departments. I'll not be reading it out, but this pertains, the first, page 14 pertains to respondent 6, 8, 16, yes.
Page 14, 15, and 16.
Yes. Again, at page 15, it highlights how many classes a week is being taken by these assistant professors. Now, if your lordship may note that they do not perform any different work to that of relative to that of the regular assistant professors. They perform the exact similar nature of work as are being performed by the regular assistant professors. Nobody disputes that. Now, the next is 197. Here in this petition, I am representing respondent 7. Again, at page 3, paragraph 4, I'm raising that ground of the lack of locus standi. In this as well, the two petitioners cleared their net only in the years 2015 and 19, whereas the respondent number 7 was appointed in the year 2014. And in that view of the matter, I'm contending that there is a delay of 9 years in challenging the appointment. Now, in similar manner, again, I've enclosed at page 12.
Here, where is that statement about the delay 9 years?
Yes, at paragraph 5. Now, Your Lordship, may kindly have page 12 also. Now, this pertains to Department of Geography under Kohima Science College. This is a letter written by the HOD, Department of Geography. Again, here the request was to create posts because the concerned department needs it, needs the post. But what does the government do? It does not create any post. It has not been creating sufficient sanctioned posts as required by the UGC mandate, as has been submitted by the state, the learned AAG. This is the situation that is prevailing. And because of this, if the department is if the concerned department in the colleges need it, the government is obliged to arrange it. This is the state of affairs as has been aptly submitted by my learned senior friend. And therefore, I have enclosed just in bits and pieces to highlight in general the stark reality that is prevailing in the colleges insofar as the posts of assistant professors are concerned. Now, I'm wrapping it up. Again, of a similar nature, without any locus in writ petition 198. I'm representing respondent 6, 7, 10, 13 and 14.
6,
7, 10, 13 and 14. Again, in view of the omnibus nature of the petitions and the defective manner in which it has been filed, in this petition also, the respondent number 7 Your Lordship, we currently have page 3. Now here, in regard to respondent 7, she is currently teaching at State College of Teachers Education. Now, as per the then 2003 service rule, which the petitioner has highlighted yesterday, the requirement is not NET, it's B.Ed, because they teach the subject of B.Ed to the students. Now, I've made the averment that she was appointed on 30/5/2014 at State College of Teachers Education. As per Rule 10.1, read with Rule 10.2 of the Nagaland Education Service Rule 2003, the requisite educational qualifications to teach the subject of education in SET are Master's Degree in Education and Bachelor's of Education. And there is no requirement of NET, except for preference that was existing then. Therefore, the petitioners have to show that they possess the qualifications of MA Education and B.Ed at the time when the deponent was appointed in SET in 2014. Now this, again, categorical statement has not been controverted by the petitioners by filing an affidavit in reply. And in the...
So you're saying that the petitioner does not have the...
They do not possess NET. B.Ed. When the respondent 7 was appointed in the year 2014. Now, at page 4 of my affidavit, they have admitted in the petition that they have also enclosed their certificate, NET certificate, at page 4, paragraph 5, as stated, that the petitioners cleared their NET only in the year 2019. Now, whereas the respondents were appointed back in the year 2012, 2014, and 2016. Therefore, as well, there is no locus to maintain this petition. Now, the last petition is with petition 208. I'm representing sole respondent, respondent number 5.
Respondent number
5. Paragraph 4 and 5 is my...
Just leave it.
Paragraph 4 and 5. Again here, the respondent 5 was appointed in the year 2013, whereas the petitioners declared their net only in 2020. Absolute lack of any locus standi in all the petitions. Now, allow me to just cite one citation just to supplement my submissions on the lack of locus as well as delay in latches. Now, in this, I'm relying on paragraph 11 and paragraph 13. Just part of it. Paragraph 11 and 13. This was also a case where teachers were appointed back in the year 2001, 2003 in Himachal Pradesh. Subsequently, they were regularized after Uma Devi, and then their contractual appointments as well as regularization was challenged. That is the background. Paragraph 11, the Supreme Court says, at the outset, it is to be noted that the schemes in questions were notified in the years 2001 and 3, under which appointments were made with regard to primary assistant teachers and teachers in other categories. At the relevant point of time, nobody has questioned either the schemes or the appointments. It is the specific case of the respondent state that such appointments have not affected the petitioners, and the department was not in a position to leave the schools, teachers deficient for long, since it would have affected the studies of the students very badly. Therefore, it was the case of the state that teachers had been appointed under various schemes at that point of time, and such appointments have been made up to the year 2007 and have no impact on the appellants, since they have completed their 2-year JBT training in the year 2011. As is evident from the order under appeal passed by the division bench of the High Court, the appellant read petitioners have not even chosen to file rejoinder, and the stand taken by the state thus has remained uncontroverted. This is the relevant portion I'm relying on. Further, it is also to be noted that when such appointments were made during the years 2001 and 2003, the writ petitions came to be filed in the years 2012 and 2013. As the writ petitioners have claimed interest for their appointment, the division bench of the High Court has rightly held that such petitions cannot be considered as the public interest litigation. Such a writ petition, which was filed by the petitioners who came to be qualified only in the year 2011, are not entitled for any relief on the ground of unexplained laches and inordinate delay of more than about 10 years in approaching the court for questioning the appointments. And paragraph 13, it talks about the regularization, but I would just like to emphasize on the position that because of no fault of the respondent, they cannot be terminated in the manner in which this petition has been filed. Just 5 lines. It is true.
Yes.
Paragraph 13. It is true that in the initial schemes notified by the government, there was a condition that such appointees should not seek regularization/absorption, but at the same time, for no fault of them, they cannot be denied regularization or absorption. It is in view of the requirement of the state, their services were extended from time to time, and now all the appointees have completed more than 15 years of service. Now again, it goes on to hold, and the Supreme Court also upholds the regularization of these teachers. Now therefore, Your Lordship had made a query yesterday as to why they were being continued. It is on the requirement by the state, not because of the mere asking of the respondents. On the requirement of the state, they are being continued. This is a situation that is prevailing, that has prevailed in this case as well, and in our case as well. That's the point I want to make.
Because initial appointment, the initial, in the advertisement, it clearly stated that it will be only for a period of 1 year.
But my contention is that there is nothing that stops the state government from continuing it, if they require it in the exigency of service. And that has been also been highlighted by the Supreme Court as well. Not just in this case, the other case that I'm going to rely on. Now, therefore, as far as the maintainability of the petition is concerned, my humble submission is that these petitions are not maintainable at all because of the lack of locus standi. The petitioners could not have.
Yeah, that is another aspect.
Now that is one of the ground. Now, on merits, I have a short submission to make. Before that, allow me to just take your lordship to one point to clarify. Now the state has taken without any material being enclosed in the petitions, the petitioners, they made a, they contend that some of the posts are sanctioned. Now, this is not true. Now, in regard to this, allow me to refer to one petition, 188.
$188.
188. I'll just refer to one of the respondents which I'm representing, respondent number 10, page 40. Page 40.
1 minute, 1 minute. Affidavit of
No, just
R70.
the writ petition.
Oh, the writ petition. Yes.
Page 40, this is the appointment order of one respondent number 10. Yes, page 40.
Yes.
Respondent number 10, again at clause 2, which I've already referred to. It says the engagement is purely made on temporary basis against the retirement vacancy. Now this clause, as I've already submitted this, is used in certain situations where the retirement vacancy or deputation vacancy or maybe maternity vacancies are caused. Now in regard to this, the petitioners simply rely on this statement just to say or to contend that this is against sanctioned post. But it's not true. Now, in regard to this, your lordship may have
because it says retirement vacancy.
Yes, yes, no doubt a vacancy has been created. But if your lordship will see, the state has contended, has made a specific statement in their affidavit that none of the respondents are occupying sanctioned posts. Now that has, again, it has remained uncontroverted. Now, in one of the extension orders at page it has not been paginated. But 51. If I'm not mistaken, it starts with notification.
Yes, notification.
Yes, now this,
July 23.
as has already been submitted, this being the third round of litigation, the second petition was dismissed on the ground of maintainability. Of course, liberty was granted. Now, pursuant to this, the state started issuing these consolidated extension orders instead of separate extension orders for these assistant contractual professors. Now, in this notification, the respondent number 10, he appears at page 52, serial number 32. And under the subject of commerce. Yes. Now, this is under Dimapur Government College, Dimapur. And 4 of them are teaching commerce. 4 assistant professors on contract basis. Now, if your lordship would like to have now the affidavit in opposition filed by the state, this is corroborated by the table as has been prepared by the department. In this petition at page 72.
Page 72.
At column number 2 is Dimapur Government College, Dimapur. If your lordship come down to serial number 12, subject of commerce. 6 of them are regular and 4 of them are contractual.
F is fixed.
Yes, F is fixed, R is regular. So I have the latest extension order which has been issued by the state. This is 17 July 2025. And in view of the, if your lordship will recall, one of my respondents, she resigned. Now, earlier it was 145 of those who have been serving on fixed pay in non-sanctioned posts. Now it came down to 144. And therefore, without any material or without any evidence, there is no basis for this court to come to a conclusion that certain respondents are appointed to sanctioned posts. That is the point I just wanted to make. And just for my own benefit, on the point of locus, the Supreme Court judgment I relied on, I would also like to, for your lordship to refer to the division bench which was assailed and which was upheld. Now, this is the division bench judgment passed by the High Court of Himachal Pradesh. Now, your lordship may kindly have paragraph 14.
Yes.
It is apt to record herein that the writ petitioners were not eligible at the relevant point of time, and no one questioned the selection of the teachers at the relevant point of time, even at the time when regularization was made. And the court went on to deal with the moot question at paragraph 18 of this case. Paragraph 18. The core question is, can the person who became eligible later on and had low locus at that particular point of time question the same on the ground that the appointments are bad? Now this, being our case, it is my humble submission that the petition deserves to be dismissed on this ground alone. Now, on merit, allow me to just make a short submission.
Okay. This is the High Court judgment.
Yes,
which
that was upheld by the Supreme Court. Now the petitioners, they heavily rely on the case of Uma Devi. But if we carefully look at it, the ratio decidendi of Uma Devi is clearly not applicable, not at all applicable to the instant case. In fact, the ratio of Uma Devi pertains to, the first is whether employees who have served for long continuous period, whether they can seek for regularization, one question, and whether the high courts can direct. Or grant regulation. Those are the two points of contention which was raised before Uma Devi. Those are the ratios. Now, even though that may be the case, the Supreme Court discussed on the concept of this temporary appointment or the illegal and irregular appointment. Now, in this regard, allow me to just read out two paragraphs from Uma Devi and how the Supreme Court has said, 2006 4 SSC 1, and how the Supreme Court has dealt with the question and how the courts should balance the rights of the contractual appointees, the temporary appointments, and the temporary appointments. I'm relying on paragraph 12 and 45. page 22. Paragraph 12. Now, Supreme Court, after discussing the scheme for appointment under Article 14, says, in spite of this scheme, there may be occasions when the sovereign state or its instrumentalities will have to employ persons in posts which are temporary or on daily wages as additional hands, or taking them in without following the required procedure, to discharge the duties in respect of the posts that are sanctioned and that are required to be filled in terms of the relevant procedure established by the Constitution, or for work in temporary posts or projects that are not needed permanently. This right of the Union or of the state government cannot but be recognized, and there is nothing in the Constitution which prohibits such engaging of persons temporarily or on daily wages to meet the needs of the situation. But the fact that such engagements are resorted to cannot be used to defeat the very scheme of public employment, nor can a court say that the Union or the state governments do not have the right to engage persons in various capacities for a duration or until the work in a particular project is completed. Once this right of the government is recognized and the mandate of the constitutional requirement for public employment is respected, there cannot be much difficulty in coming to the conclusion that it is ordinarily not proper for the courts, whether acting under Article 226 of the Constitution or under Article 32 of the Constitution, to direct absorption in permanent employment of those who have been engaged without following a due process of selection as envisaged by the constitutional scheme. Therefore, the right of the Union or the state to engage temporary appointments is not disputed by the court. But the question comes as to when the appointments are being continued on post without advertisement, and finally the state resort to regularization. That is the issue. Now at paragraph 45, I'm submitting that the respondents, for no fault of theirs, should be terminated in the manner in which this petition has been filed, because they are trying to eke out a livelihood as well. And this right of the respondents, the Supreme Court has recognized that it has to be balanced by the courts. Now at 45, while directing that appointments, temporary or casual, be regularized or made permanent, the courts are swayed by the fact that the person concerned has worked for some time, and in some cases for a considerable length of time. It is not as if the person who accepts an engagement, either temporary or casual in nature, is not aware of the nature of his employment. He accepts the employment with open eyes. It may be true that he is not in a position to bargain, not at arm's length, since he might have been searching for some employment so as to eke out his livelihood and accepts whatever he gets. But on the ground alone, it would not be appropriate to jettison the constitutional scheme of appointment and to take the view that a person who has temporarily or casually got employed should be directed to be continued permanently. By doing so, it will be creating another mode of public employment which is not permissible. Now, in this case, if I may submit that we are not seeking for realization or absorption. The context of this paragraph follows that, but I'm relying on the subsequent paragraph. But if the court were to void a contractual employment of this nature on the ground that the parties were not having equal bargaining power, that too would not enable the court to grant any relief to that employee. A total embargo on such casual or temporary employment is not possible, given the exigencies of administration. If imposed, would only mean that some people would at least get employment temporarily, contractually or casually, would not be getting even that employment when securing of such employment brings at least some succor to them. Now, I'm submitting that the respondent's case are covered by this statement of law made by the Supreme Court. Now, in this regard, I may be allowed to rely on one citation, 2017. I may have forgotten to provide the book list for this case, but may I just say it? 2017 3 SCC. 2017 3 SCC 410. Now, this is the case which my learned senior friend had referred to, District Bar Association Pandipora's case. Now, in this, 3 judgments of the Supreme Court has again reiterated on the ratio of what Uma Devi held and how the High Courts as well as the state governments has misinterpreted the law laid down by Uma Devi.
Could it be paras?
Paragraph 10, 11, 12, and 26. Now, in this judgment, the Supreme Court, it laid down, now on the concept, on the aspect of irregular and illegal appointment. The Supreme Court says, may I just read out?
Yes, yes.
The third aspect of Uma Devi, which bears notice, is the distinction between an irregular and illegal appointment. While answering the question of whether an appointment is irregular or illegal, the court would have to inquire as to whether the appointment process adopted was tainted by the vice of non-adherence to any essential prerequisite or is liable to be faulted on account of the lack of a fair process of recruitment. There may be varied circumstances in which an ad hoc or temporary appointment may be made. The power of the employer to make a temporary appointment, if the exigencies of the situation so demand, cannot be disputed. The exercise of power, however, stands vitiated if it is found that the exercise undertaken, three clauses quotes, was not in the exigencies of administration, or where the procedure adopted was violative of Articles 14 and 16 of the Constitution, or where the recruitment process was overridden by the vice of nepotism, bias, or malefides. Now, I'm contending that the appointment of the respondents, private respondents, are irregular in nature because they were made in the exigencies of administration. And merely because of the lack of an advertisement, it would not render the appointment illegal. Now, the last case is the paragraphs I'm relying on are 7 and 9. Before I read out, I may just be allowed to make one submission. 7 and 9. Now, Your Lordship has noticed that in the Higher Education Service Rule 2003 or 2015, there is no provision as to how the appointment of the assistant professor, as to how appointments of this nature are to be regulated. The service rule speaks only about appointment to vacant sanctioned post. Now, in that regard, the appointment has to follow the due procedure. Advertisement has to be issued by the NPSC and all and whatnot. Now, for appointment...
But in the UGC regulations...
Yes, even in the UGC regulation, it is there. But does our appointment come under the ambit of the UGC regulation is the question I want to raise. Because UGC says it has to be the salary. The minimum scale of pay as has been enjoyed by the regular. We are not. We are fixed pay. Now, therefore, I'm contending that the manner our appointment is not covered neither by the service rules, whether it be to the 2013 or 2015, or the UGC regulation. But the state in exigency went ahead with our appointment. Now, on a fixed pay it initially started with 8,000. Thereafter, it was increased to 12,000. Thereafter, 20, now 30. This manner of appointment is nowhere regulated by any of the rules or the OMs or the notifications. This is sui generis to the department, to this case, to the department only. In that context, when we take into account whether the appointment is illegal or not, now an appointment has to be dehors a service rule or dehors the Constitution to be illegal. When our appointment is not dehors any of the rules or the regulations as provided in this, as we have looked into it in these petitions, it cannot be said that our appointment is illegal. In this regard, I'm relying on one 2018-13 SSC 432. Now, here in this judgment also, the Supreme Court has been slowly clarifying on the jurisprudence laid down by the judgment in Uma Devi. Allow me to just read out paragraph 7 also for my own benefit. When we consider the prevailing scenario, it is painful to note that the decision in Uma Devi has not been properly understood and rather wrongly applied by various state governments. We have called for the data in the instance case to ensure as to how many employees were working on contract basis or ad hoc basis or daily wage basis in different state departments. We can take judicial notice that widely aforesaid practice has been continued. Though this court has emphasized that incumbents should be appointed on a regular basis as per rules, but new device of making appointment on contract basis has been adopted. Employment is offered on daily wage basis in exploitative forms. This situation was not envisaged by Uma Devi. The prime intent of the decision was that the employment process should be by fair means and not by backdoor entry and in the available pay scale. That spirit of the Uma Devi has been ignored and conveniently overlooked by the various state governments and authorities. We regretfully make the observation that Uma Devi has not been implemented in its true spirit and has not been followed in its spirit and substance. It is being used only as a tool for not regularizing the services of incumbents. They are being continued in service without payment of due salary for which they are entitled on the basis of Articles 14, 16, read with Articles 34(1)(d) of the Constitution of India, as if they have no constitutional protection as envisaged in D.S. Nakara versus Union of India, from cradle to grave. In heydays of life, they are serving on exploitative terms with no guarantee of livelihood to be continued, and in old age they are going to be destituted, there being no provision for pension, retirement benefits, etc. There is clear contravention of constitutional provisions and aspirations of downtrodden class. They do have equal rights, and to make them equals, they require protection and cannot be dealt with arbitrarily. The kind of treatment meted out is not only bad, but equally unconstitutional and is denial of rights. We have to strike a balance to really implement the ideology of Uma Devi. Thus, the time has come to stop the situation where Uma Devi can be permitted to be flouted, whereas this court has interdicted such employment way back in the year 2006. The employment cannot be on exploitative terms, and every post should be filled by regular employment, but a new device has been adopted for making appointment on payment of paltry system, on contract, ad hoc basis, or otherwise. This kind of action is not permissible when we consider the pit and substance of true spirit in Uma Devi. Now, this case also concerned the question of regularization. Now at paragraph 9, my point, I'm relying on this one. The High Court dismissed the writ application relying on a decision in Uma Devi. But the appellants were employed basically in the year 1993. They had rendered service for 3 years when they were offered a service on contract basis. It was not the case of backdoor entry, and there were no rules in place for offering such kind of appointment. There were no rules in place for offering such kind of appointment. Thus, the appointment could not be said to be illegal and in contravention of rules, as there were no such rules available at the relevant point of time when their temporary status was conferred with effect from so-and-so. Therefore, I'm submitting that there's no rules that govern this kind of appointment, contract appointment. The rules which exist as of today pertains only to sanction posts and how they are to be recruited. The UGC regulation speaks about contract, but it says it has to be minimum scale of pay as the regular assistant professors. Therefore, in that view of the matter, I'm submitting that our appointments are neither backdoor nor illegal, and therefore, despite the contention being made on the maintainability of the petition, I submit that even on merits, the petition deserves to be dismissed. I rest my submissions. I'm obliged.
Can you just give that citation to the that one which you could not provide? 2017, I think. Yes.
May it please, Your Lordship?
Yes.
I'm in 4 different writ petitions, Lordship.
Okay.
So this is the list. Of. But Your Lordship, during the course of the day, I'll be supplying the details of the respondents, Lordship.
Yes, that also is necessary.
Yes,
the
yes,
date
Lordship.
of the appointment. Then
in fact, we met, but we have left out in the chamber, so we could not rest. Apologies on that. Lordship, at the outset, I endorse to what my learned senior counsel has submitted, as well as my learned friend Iralu, regarding the maintainability, delay, as well as to the various judgments that is placed, especially the Uma Devi. Lordship, first I may be allowed to submit on WPC 188/2023. In this, I have filed my counter affidavit differently because the mode of appointment and then the facts are different. And then the petition, the writ petition was made in such a way that it really made us confused. So we had to file differently the counter affidavit, Your Lordship.
Oh, different respondents, different affidavits.
Yes, Your Lordship. Because the mode of appointment as well as the facts are different, Your Lordship.
Okay. So you are appearing for 188.
In 188, I'm appearing for respondent number 5, 6, and 9.
6, 9.
Lordship?
5, 10, 6, 9. Okay.
Lordship, with regard to, I'll just mention the paragraphs. I won't take much of your time, Your Lordship.
Yes. Just give me the paragraphs
Yes.
only for particular.
First,
for the
the
particular
first one is the
respondent.
maintainability. That is para number 2. I have preliminary objection regarding maintainability because the respondent was appointed on 2011, whereas the minimum requisite qualification of Masters of Commerce, the petitioners, they only passed out in the year 2014 and 15. And so I'm praying for maintainability in this. And then, Your Lordship, that is para number 2. My main contention is at para number 10. It starts from para number 10, Your Lordship. Para number 10, that is, he was appointed at fixed pay on retirement. But Lordship, on retirement, but however, he is under fixed pay at the moment, till now. That is A, Lordship, para number 10A. B, Your Lordship, if you kindly go to para number B. Now, he was allowed the government respondents has allowed for screening committee for, regarding suitability tests for his regularization, Lordship, here. So, which is still pending disposal in this case, Lordship.
So he appeared for the screening?
Yes, Your Lordship, but it is still pending, it is still pending. This is a very different case in this. So, Lordship, all the details are mentioned in para number C also. D is, that is the meeting minutes, and then E and F, Your Lordship, those are my main contention in this for respondent number 5. And moreover, Your Lordship, here, in my para number G, the respondent number 5 here, he was, no doubt he was initially appointed in 2011 as per the Nagaland Higher Education Service Rule 2003, wherein in this, the net qualification was not mandatory, Your Lordship also knows. Nevertheless, Your Lordship, the answering deponent is net qualified, which is mandated as per 2015. Yes, Your Lordship. And so that is my submission regarding respondent number 5. Yes, Your Lordship. And then in this, even the state government, in their affidavit opposition, they have already stated that, yes, it's under process for regularization. They have already mentioned in their affidavit opposition, Your Lordship.
Then R6.
Yes, Lordship, if you can refer to government affidavit, it's at page number para 8. Para 8. Page number 3, Lordship, page number 4. The first para. Yes, respondent number 5 was appointed on contractual basis against post vacancy due to expire of incumbent, and it was considered for walk-in interview for regularization, and respondent number 5 has attended the interview. However, till date he has not been regularized. Lordship, that is the reply of the government. His regularization is under consideration, Lordship, in this case. Lordship, with regard to respondent number 6, with regard to respondent number 6, he was appointed, para number 6, Your Lordship, if you can kindly go to para number 6, that is my main submission. The next page, Your Lordship, page number 3, having been serving as assistant professor at Dimapur Government College on fixed pay per month against deputation vacancy, Your Lordship. This is a deputation vacancy. And so even in the affidavit of the government, they have admitted that this post has been filled against deputation, Lordship.
And the person who went on deputation is still serving in NPSC?
Yes, that's what, as per, while filing this affidavit, while filing our counter. But however, Your Lordship, only yesterday we came to know that there was certain development, that the respondent number 6 has been redeployed to Fazal Ali on the account of creation of a new Department of Commerce at Fazal Ali Mahokchong, Your Lordship. So to that, we have already filed one small affidavit to bring on a record that he has been redeployed. On 12 May 2025, Shri Likok Unan Longkumer has been redeployed to Fazal Ali College, Mukokchong, on the account of introduction of new commerce stream.
But that also in the same conditions, the fixed pay?
Yes, Your Lordship, fixed pay.
And what about the qualifications? He obtained his net qualification?
Yes, Your Lordship.
In 2020?
He obtained his net qualification in the year 2020.
And what about the petitioner?
The petitioner, here, 2000. Your Lordship, 2019. And 2017.
That means before you obtained in the year 2020?
Yes, Your Lordship. But however, his vacancy, his post was vacant because of deputation, Your Lordship, initially. Lordship, respondent number 9. Even the respondent number 9 has preliminary objection, that is in para number 2, that the petitioner number 2 was not net qualified as on 24/8/2016, where the answering deponent was appointed to the post of assistant professor. Lordship, here to my para number 7.
1 minute.
Yes.
This one is 9. Yes.
To my para number 7, this is my contention. Here, the respondent number 9 was appointed through advertisement, Your Lordship. The respondent number 4, that is the state authority, they have circulated an advertisement. The advertisement is at page number 11, Your Lordship. Page number 11, annexure 8.2. Lordship, here to the principal, this was circulated to all the colleges by the State Education Department committee for introduction of honors and new subject as given below. So this was given to all the colleges, government colleges, and in the meantime, the respondent has also applied. And Your Lordship, to next page, to page number 13. If you could kindly turn to page number 13. This is the notice. Says applicants for the post of assistant professor in sociology, psychology, and commerce are hereby informed to take note of the date of suitability test as given below. So,
but where is the advertisement?
Yes, this was the 188. This was the circulation. Page number 11 is the circulation. That was given by the higher education.
Request to take up necessary action for introduction. No, this is only for steps to take up necessary action for introduction of honors and additional subjects.
Yes. So, sir, madam, in the state education committee meeting held, SEC recommended the following introduction of honors, and so this was introduced. They recommended, and so likewise on seeing that they have applied.
This is not an advertisement.
It's a circulation, Your Lordship.
It's
Circular.
a circulation for introducing new subjects.
Yes, but however, if you could kindly turn to page number 13, Your Lordship. Page number 13. This was issued by the Director of Higher Education, Nagaland. Notice: applicants for post of assistant professor in sociology, psychology, and commerce. These were the list, Lordship. All these were applicants. All this, and then in page number 14, Your Lordship, the respondent number 9 is at 51, serial number 51. Many of them, many applicants were there, Your Lordship, in this. She was at serial number 51. And so on 12th July 2016, Your Lordship, if you could kindly turn to page number 15.
This is R9, no?
Yes, Your Lordship. Page number 15, Your Lordship. Page number 15 is the following candidates have been selected as this was issued on 12 July 2016 by the Director of the Higher Education, Nagaland, Kohima. It says the following candidates have been selected as Assistant Professor in Sociology. These were the list. The respondent number 9 is at the third one, Your Lordship, the third column. The third column, the following candidates, in commerce, she was at waiting list number 1. So One of the main candidates did not appear, so in the meantime, she was selected. And even in the appointment, Lordship, the appointment order of the respondent number 9, it says, Srimati Nakshi Sangla Lamtor, waiting list number 1, is temporarily engaged as assistant professor, commerce, against the non-report of Srimati Meno Thori and posted as assistant professor, fixed Dimapur Government College, Dimapur, Lordship. That was the appointment order. And likewise, she joined the service, and time to time, her appointment was extended, Lordship. The submission, the allegation of the petitioner stating that the respondent has entered this post illegally is denied because she has undergone the screening test, as well as she has completed the screening test, as well as she was appointed on merit list, Lordship, on merit. Lordship,
Yes.
now WPC 191. This I'm for respondent number 13.
$191.
Yes, Lordship, 191. I filed my counter affidavit for this also.
Here you are for respondent.
Respondent number 13, Your Lordship.
13.
Yes, Your Lordship.
Yes.
Lordship, to my para number 2, I have preliminary objection regarding to maintainability in this present case also, because, Lordship, the reason is the petitioner was not net qualified as on 24/5/2017 when the answering deponent was appointed to the post of assistant professor as Dimapur Government College, Dimapur Government College, and this itself, the respondent number 13 is praying for dismissal of this instance of the writ petition, Lordship. Lordship, to my para number 8. She was initially appointed on 24/5/2017 on fixed pay of 20,000 per month, Lordship, and thereafter his service was extended. And Lordship, in one of the forwarding letter submitted by the additional director, Lordship, it's at page number 11. It's at page number 11. The additional director has stated that it specifically mentioned about the respondent number 13's service in the college, stating that it was much needed and also prayed for extra teachers. There were the principal, the government authorities were praying for extra teachers also, here at page number 11, Your Lordship. And so in this regard, it is to be stated that extension of service is required as Dimapur Government College Dimapur has 2 sections and requires extra teacher. The workload of the applicant as per workload schedule submitted is 16 classes per week, Your Lordship. So there this respondents are working without any break, Your Lordship. Lordship, my contention is page number, para number 2, 8, para number 2, 8, and 12, Your Lordship.
2, 8, and 12, 11.
Yes, Your Lordship. Lordship, with petition number 192. I am for respondent number 6 and 7, Lordship.
92. Respondent number
6 and 7.
6 and 7.
Lordship, respondent number 6. WPC 192.
Yes.
Lordship, WPC 192 for respondent number 6 and 7.
They also separate.
Yes, Your Lordship.
6. Yes. What is the stand of R6?
The stand is even she has preliminary objection. Number one is she was appointed. The respondent number 6 was appointed on 12/7/2016 by respondent number 4 as assistant professor in psychology, Lordship, at Dimapur Government College, Dimapur, Nagaland. Lordship, to my number B, at the time when the answering deponent was appointed, the petitioner number 2 was not eligible for appointment to the post of assistant professor, as petitioner number 2 acquired the minimum requisite master in philosophy only in the year 2019. Moreover, petitioner number 2 is a master in philosophy, Lordship, not psychology, whereas the answering deponent is masters in psychology, which is a totally different stream or subject, Lordship. That is one preliminary objection that respondent number 6 has, and the other one is the petitioner number 1. The petitioner number 1 was also not net qualified for appointment to the post of lectureship, as the petitioner was eligible only in the year 2018. So the respondent number 6 is of the opinion that when the petitioners are not even eligible for appointment, they do not have the legal standing to question the appointment of the answering deponent to the said post, Your Lordship. Therefore, in the preliminary objection, the respondent number 6 is bringing this instant challenging to the post of assistant professor of psychology Dimapur is liable to be dismissed, be not maintainability on the ground of law. That is my preliminary objection, Your Lordship. My main contention regarding the merit of the case, Your Lordship, is at para number 8. Para number 8, page number 4, Your Lordship.
8, yes.
Yes, page number 4. Even here also, the respondent number 6 was selected through the State Education Committee. Like respondent number 7 at WPC 188, Your Lordship. They were the applicants. They were among one of the applicants, Your Lordship. And then
That one where there was a selection
Yes,
process.
Your Lordship. And then here, her name is, huh? 190.
This is 192.
Yes. Your Lordship, if you kindly go to page number 18, annexure A5, column number 2. She was
psychology.
Yes, serial number 1, waiting list, serial number 1, record view. And in the,
R6.
yes, R6. The next page is her appointment order. Waiting list, para number 1, Srimati Rokoview, waiting list number 1 is temporarily engaged as against the resignation of one so and so. So she was appointed in this post, Your Lordship. Mm, 192 for respondent number 6. Or it was 192. No. Your Lordship, my main condition is para number 8 itself, Your Lordship.
Para 8.
Yes, Your Lordship.
Yes.
Lordship, in the petition, there was the petitioner have stated that to advertise the post in the NPSC, Lordship. But however, the respondent is saying that whether the petitioner number 1 is made aware and applied to the post of psychology when it was advertised. 4 posts was advertised. Whether she was made, whether she applied on that post itself or not, because here even the respondents they have applied to this post itself, Lordship. When the NPNC they have advertised on 2021 for Common Educational Service 2018, Lordship. In this also, the respondents are questioning the petitioners whether they are applying for the post when the NPSC are advertising, Lordship. Because the respondents are applying and then appearing, Lordship, in this post. Lordship, we have for respondent number 7. For respondent number 7, Lordship, even here, the respondent number 7 has preliminary objection. Para number 2A. I may be allowed to read, Lordship, this para. Page number 2A. Para number 2, Your Lordship. Page number 2.
Yes.
The answering deponent has received his master in philosophy in the year 2005, net qualified on 2006, received his doctorate in the year 2013, and appointed to the post of assistant professor on contractual basis on 31/10/2018, wherein the petitioner number 2 was qualified to the post of assistant professor only from 2019, Your Lordship, 2019. The petitioner number 1 is MS Psychology, which is completely a different field subject from the answering deponent.
R7 is a doctorate in philosophy.
Yes, Your Lordship.
And petitioner 1 is
is MS Psychology. Petitioner, Your Lordship, petitioner number 2 was qualified to the post of assistant professor only from 2019. 2019. Yes. A, the last line, only from 22 to 2019. Yes.
Whereas R7 was appointed on
2018.
31/10/18.
Yes. And then petitioner number 1 is from a different field, subject, Lordship. It's from a different field. Different field, Lordship. Lordship, my main contention also is at para number 8. Lordship, here the respondent, the respondent number 7, and then in their faculty, in their department, Lordship, there are 6 of them. At present, there are 6 of them. 4 of them are associate professor regularized, and then they have been serving for a very long time. There are two respondents here, where both of them, they only possess the doctorate, Lordship. Here in their subject, in 5th semester, 6th and 7th semester, they have research dissertation, and then these 4 who are regularized, they do not possess the doctorate, and so these 2 contract who are under contract, one is the respondent. They are for the research purpose for 5th semester, 6th semester, and 7th semester. They are only qualified. They are the only qualified teachers to teach in this subject, in these semesters, Your Lordship. And then both of them are under contract on fixed pay. The other regularized assistant professors does not possess the requisite qualification to teach semester 5, 6, and 7, Lordship, where it is for research internship and research dissertation, Lordship. In order to teach this subject, one should possess the doctorate, and then only 2 contract lecturers possess these 2. Lordship, my contention to this is at para number 8 also, Lordship. I will not go into the detail. And last, Lordship, and para number 14.
14.
Lordship, in WPC 196. WPC 196.
Yes.
Lordship, my in this
year for
respondent number 9, Your Lordship. Para number 2, even in this I have preliminary objection, Your Lordship. In para number 2, Your Lordship. Lordship.
Yes.
Lordship, page number 2, para number 2. Page number 2, para number 2. Lordship, in this also I have preliminary objection because here the respondent number 9, Dr. Hanatia, was appointed on 14/7/2016 as assistant professor in sociology. Lordship, at the time when the answering deponent was appointed, the petitioner was not eligible for appointment to the post of assistant professor, as the petitioner acquired the minimum requisite qualification in master in sociology only on 8/8/2017. 8/8/2017, Lordship. Even here also, Lordship, the respondent number 9, he was appointed on the same mode as respondent number 9 in WPC 188 and respondent number 6 in WPC 192 through selection mode. Her name is reflected through selection mode. Lordship, here her name has been reflected at page number 17, Lordship. This is the temporary engagement at serial number 4. Lordship, my apologies. If you could kindly turn to page number 15. The candidate, the name of the respondent number 9.
This is the list for the test.
Yes, Your Lordship.
But here you don't have that result list, like in the other petitions.
Lordship, but in others it's there. Her name is also reflected.
It's there.
I will show you in that, Lordship, but I have failed to annex in this.
Not annexed.
Yes, Your Lordship. However, Your Lordship, in the notice, Your Lordship, it's at page number 15, you will see her name at serial number 13. At serial number 13.
And in the select list.
Yes, that
her
is the
name
notice.
Appears at
13, serial number 13. Oh, Your Lordship.
No, I mean in that result.
Yes,
list.
result. I have failed to annex in this.
No, you just go through the other.
Yes, the other one is at serial number 2.
Serial number 2.
Yes.
Against which department?
Against sociology. In the first column.
Serial number 2.
Para number 2 is my preliminary objection, Lordship. Para number 8 is the merit, the detail of the respondent number 9 qualifications and the mode of appointment, Lordship. Lordship, my humble submission is that the policy decision of the government does not prohibit them from making contractual appointment in exceptional cases, Your Lordship, and as such, violation of office memorandum that was annexed, dated 7/7/1976 and 2001 does not arise in this, Your Lordship. And as such, I humbly pray before this Honorable Court that there is no such violation of the Constitution scheme of Article 14 and 16 of the Constitution of India, and that the question of the petitioners denying opportunity to compete in NPSC exam does not arise, because then and again the NPSC have been advertising, and moreover the respondents have been relentlessly appearing for that also, Your Lordship. And then moreover, most of the respondents here have selected through a selection process that was advertised, that was circulated by the government respondents, and then there is no backdoor appointment in this. And as such, I pray that this petition be liable to dismiss, Your Lordship. That is my humble prayer. Much obliged.
Lordship, are we continuing with the 340 or the hearing will be within specific this 188 to 189?
We can do 340 if 188 series is done. Is it done? All respondents have appeared. 188 series
to 189.
So 340, who is there in 340? The government is, What's the difference in 340?
340 is unqualified.
Unqualified what? Oh.
Without net.
No, without net.
Yes, Lordship. And while going through all this, yes, Lordship, it is their duty to defend the particular respondents by the Respondent Council. I subscribe to it. However, on my part, there are so many writ petitions, but I am only on the question of law, and I did not go through all the writ petitions, appointments, and whatever, because I'm only on the question.
Without going through their appointments, how can you challenge?
No, it's all the same. In writ petition.
No. Each case is different. That's why the court is also having a tough time.
Yes, Lordship. I shall do that. And if my Lord will kindly make it part heard and leave it for either on tomorrow, day after tomorrow, and on Thursday, I will be out of station, Lordship. I have unavoidable circumstances, so it may continue on.
If it is not today, I'll be traveling to Insang for one POXO case for trial. So that's why I'm just waiting. If it is possible today, otherwise.
You're in 340?
Yes, 340.
340.
Yes. So that is all right. If she can.
And
I have also
otherwise,
been traveling non-stop since Friday.
Yes.
Gauhati
So
by
therefore,
road.
if can be in that case next week, otherwise.
Also, my Lordship has only this week before this Honorable Court. So either
We'll have to finish it this
by
week.
Friday, but tomorrow and day after, these 3 days I'll be out of station. I have
Tomorrow
unavoidable.
and Wednesday. Till Wednesday.
Tomorrow, Wednesday, Thursday.
Thursday also.
Till Thursday. And so.
And you?
I'll be in Insang tomorrow. The whole week I'll be there for trial.
Whole week?
Evidence, yes, evidence. Because there are more than 50 witnesses. Today, if we can finish today, my Lord, that will be very kind of this court.
Let's try to finish today then. If
much.
only 340 is left.
Only 340. So if it can be finished today, that's fine.
Lordship, in that case, I also have to go through the appointment orders of all the writ petitions.
Obviously.
No, frankly, submitting before this Honorable Court, since my case is only limited, yes, I admit and I appreciate whatever the learned councils have submitted before this honorable court and whatever has been done. But my only issue here is on the question of law only. And Lordship, it appears that they have come before this honorable court submitting that the petitioners have no locus standi. On that, I'll have to submit before this honorable court and satisfy my lordship that in a backdoor appointment, when the appointment is non-est in law, all this whatever is being submitted.
No, it may be illegal, it may not be illegal, but who can challenge? Who can?
Yes, yes, yes. Who can challenge? I will satisfy my lordship on that issue. Because all those issues in the...
Someone who was not qualified at the time when they were appointed,
that's why.
That person can challenge.
That's why, lordship. Backdoor appointment has no restriction, has no prohibition, as long as if they are holding an advertised post, whether sanctioned or non-sanctioned. Lordship, I have so many citations. And
citations may be there, but whether it can be applied in the facts and circumstances.
Yes. In the present case, I have lordship. I have, and that portion I have to satisfy my lordship because it pertains to setting a precedent, and I also have to satisfy my lordship on the issue of.
Earlier case was disposed of on 2/2/2022, 6/6/2022.
Yes.
Net qualified forum. After that, pursuant to the observation made in that case, the present writ petitions were filed. It took nearly about 1 year to file the writ petition. So they got sufficient time to scrutinize what is the status of the petitioner, what is the status of the respondent. So, and my learned friend has made elaborate submission.
So I'm not
the whole
given,
day she has taken.
So that means I have no right to submit.
No. Locus, they already raised in their affidavits.
That's why I'll just submit the.
And you have not filed any rejoinder also.
Lordship, I feel that it is not necessary because on the question of just
when
my humble
there is no
submission before.
rejoinder, the court will have to take that it's not rebutted.
Lordship, when the fact is clear before this honorable court, they may laugh, they may mock or whatever. That is another question, but here the question is, I have also submitted yesterday the citations.
Opportunity will be given to you, no doubt. That's why we're wondering when to adjust.
Lordship.
That's why
So
Lordship,
on Friday,
can take up on Thursday and Friday.
On Friday.
But now Mr. Zoe is saying he will.
my learned friend can finish his submission today.
Otherwise, Lordship will be here
Only
again
the
on
reply
3rd.
part will be
Yes.
left.
On 3rd.
We can do that. Let Mr. Zoe finish his submission and then you can reply.
Yes. Even if he's away.
Yes.
All right.
3:40, huh? What's that? 3:40 already. Oh, yeah, I got it. Not 3:10, 3:40. Yes.
May I please, Your Lordship? Lordship, here I am for respondent number 1, 2, and 3. Lordship, the stand of the state respondent is that we are not denying that the petitioners have completed the master's degree along with the NET. They have completed in the year 2014 to 2022. However, Lordship, here the stand of the petitioner is alleging the state government, the state respondent, that the post has not been advertised, and which is totally false and baseless allegation. Why? Because we have stated in our paragraph 4 of our affidavit in opposition that all the posts which is sanctioned posts, which we have been requisitioned to the NPC so far till date, Lordship, which we have clearly stated in our paragraph 4 of our affidavit. And secondly, there is no violation of principle of fair play as alleged by the petitioner. The state government, in accordance with law and as per with the office memorandum, a series of office memorandum, Lordship, time and again the post has been requisitioned to the NPSC. And Lordship, from the face of the record, Lordship, if Lordship may kindly come to the petition of the petition filed by the petitioners, Lordship may, from the face of the record, if Lordship may kindly come to page 1, I will only take to the relevant portion, 175, Lordship, annexure G4, Lordship. The mode of appointment, Lordship. This is one of the this private respondent who has been appointed, Lordship. This is not 30 August 2016, Lordship, if I'm allowed to read, Lordship. In the interest of public service, the Governor of Nagaland is pleased to engage. The word here, engage, has been used, Lordship. Lordship, here, the private respondent was never been appointed, Lordship. In fact, they were engaged, and the service of Sri so-and-so as Assistant Professor, Political Science at Professor Futsuro Government College, so-and-so, on fixed pay. Earlier, they were being paying a fixed pay of rupees 20,000 only per month for a period of 1 year, and time and again, their services has been extended. And more importantly, two, the engagement is purely on temporary basis and can be terminated at any time without prior notice from either side, Lordship. And Lordship, the point 3 is important, Lordship. Here it says that so-and-so has been temporarily engaged to meet the exigency requirement of the college against non-sanctioned post, Lordship. All these appointments were made against a non-sanctioned post, Lordship. And Lordship is well aware, and Lordship will appreciate that we the state government has the higher education has been regulating by the UGC, Lordship, where as Lordship is well aware that Rule 13.0 and Rule 13.1, which talks about, Lordship may kindly come to the rule which page 90 of my affidavit in opposition. Appointment on contract basis, page 90.
No, but for this, they have to be appointed on a pay scale, which is the lowest pay scale as given to the regular employees. But you are paying them fixed pay of 20,000.
Lordship.
Or 20,000, whatever it may be.
On exigency basis,
fixed
Lordship.
emoluments paid to such contract teachers should not be less than the monthly gross salary of a regularly appointed assistant professor. So they cannot even come under this.
So, Lordship, all those time and again, Lordship, as far as the state respondent is concerned, the grade pay of rupees 2,800, which time and again we have been requisitioned to the NPC, and thereafter, Lordship, there is a series of advertisement, Lordship, which Lordship may find in page 11, Lordship, A series, Lordship.
Yes, sanctioned post you have been advertising.
Lordships, all those sanctioned posts we have been advertising, Lordship. But here is the case where all those private respondents, they have been engage on exigency basis, Lordship. And they are holding the non-sanctioned posts, Lordship.
You are alleging that they don't have net. What about that?
I have so many citations.
Lordship, Lordship, I have stated in my paragraph 9 of my affidavit, Lordship. If I am allowed to read, Lordship.
Yes.
That with regard to the statement made in paragraph 8 of the writ petition, the answering deponent begs to state that on the statement made by the petitioners stating that a private respondent number 4 to 34 as backdoor appointment, it is pretending to state herein that the respondent number 4 and 6 were appointed as assistant professor in economics subject in the year 2013 and 14. That is in the annexure G and G1 of the writ petition. Prior to the higher, they were being appointed prior to the Higher Education Service Rule 2015, Lordship, where net, and whereas the petitioner number 1 and 2 had cleared the MA Economics net only in the year 2019 and 2018, Lordship, and that has been annexure A and A1 of the writ petition, Lordship. Lordship, as far as respondent number
But
4.
14 to 18, they were appointed after the 2015 rules.
Lordship.
Yes.
As far as respondent number 4 and 6 is concerned, Lordship, 2013 and 2014,
Okay, fine.
Lordship.
4 and
Prior
6,
prior
they
to
were prior to
service
2015 rules.
Lordship.
But 14 to 19, they were appointed after the 2015 rules.
Lordship, some has been appointed after.
Yes.
Some has been appointed
So
after.
how can they be appointed without net?
Lordship, because of that, Lordship may kindly come to the notification, Lordship. Page 297, Lordship. This is the notification from the Higher Technical Education Department, Lordship. 297, annexure E.
Yes.
If I'm allowed to read. In notification dated 30 Jan 2018, in pursuance to the decision taken in the State Level Assurance Coordination Committee, SLQ-ACC, meeting held on 30/10/2017, and in accordance with Rule number 3 and 4 of the UGC Regulations 2010, it is hereby notified to the in-service fixed pay teachers without net/PhD to clear net within 2 years and PhD within 3 years, failure of which there shall be no further service extension. Further, any application for appointment to the post of assistant professor without net PhD shall not be entertained henceforth. And Lordship, thereafter, a subsequent notification was also issued by the Higher and Technical Education, which is at page 298, Lordship. The notification dated 29 August 2018. This is to notify that it is a prerequisite condition under the UGC norms that anyone teaching in the college should possess net/PhD. This principle will also apply to all the lecturers who are presently serving on fixed pay, without which further service extension will not be entertained forthwith. This supersedes the department's earlier notification dated so and so with immediate effect, Lordship. Lordship, now the Higher Technical Education Department has come up with a notification saying that by this notification, Lordship, it becomes a mandatory to.
But even before this, by 2015 rules, it was made mandatory. Where is this? What is this UGC regulation 3 and 4? Let's see.
Lordship, in this question, UGC regulation 20 covers them. Under UGC regulation 2010, it is, yes. And this, there are Supreme Court citation here between the state regulation and the UGC. UGC will prevail. I have those citations, Lordship. So here, the question of day in 2003 higher education services, net is not mandatory. That has been stated in the UGC.
Lordship,
2003. However, I want to appraise my lordship that UGC enforcement overrules the rules of the state.
Lordship, Lordship, this private respondent 3 to 34, they will not come into the rules. Why? Because they are on fixed pay, Lordship. They are not governed by the service rule, Lordship. They cannot come either on the rules, Lordship. For the fact that, Lordship, they are appointed on the exigency and they are appointed without sanction post, Lordship. They were appointed on the need basis, Lordship. And their service has been extended from time to time, Lordship. And Lordship, I have clearly read it out the record, from the face of the record, Lordship. They are neither been appointed, Lordship. They are, in fact, they have been engaged, Lordship.
But they are doing the same duties as regular employees. They are also teaching the students. That is the problem. So without qualification, how the government has appointed them?
Lordship, therefore, Lordship, government has come with a notification to possess a certain...
you have tried to rectify.
Lordship.
Okay, then?
Therefore, Lordship, my humble submission before Lordship is, Lordship, there is no violation of Article 14 and 16 of the Constitution of India, Lordship. And the petitioner has failed to make out the case by invoking Article 226 of the Constitution of India, Lordship. Therefore, it is to be dismissed.
Okay. Yes.
I rest my...
Apologies.
Oh, you are here also?
Yeah, in this matter, I'm representing one respondent, number 9. Yes. Now I adopt the submissions which I've made in the connected petitions to the effect that the appointment is not illegal in view of the fact that the appointment is not divorced any of the rules or the OMs, the notifications.
No, okay, fine. We go that by what you're saying, that they are not governed by the UGC regulations as well as the service rules, but they have to teach the children.
Yes,
which means
in my case, subsequently, I obtained NET. In my case, subsequently. Yes, initially I was appointed without NET, admittedly. In the affidavit, I've enclosed the NET certificate. In view of the government's notification, certain respondents have obtained NET subsequently. And my certificate is enclosed as Annexure 1, A1, sorry. Respondent number 9.
Yes, so in your affidavit,
Page 8 is the certificate.
and any other grounds?
No. In the connected petitions, I may have inadvertently missed one citation, which I may be allowed to place. It will cover this also. 2024, excuse me, 2024, 3 SCC, 799. And this was a case where the appointment of 6 district judges were challenged. The matter was placed before the Constitution Bench. The Constitution Bench, despite finding the illegality in this appointment, found that after 6 years of having served in service, they ought not to be unseated. I'm submitting that in the same vein, this was done in the public interest. In the same vein, all the respondents They have now served at least 7 years and at most more than 15 years of service. And therefore, given the fact that your lordship may already have taken judicial notice of the prevailing situation of the higher education in the state of Nagaland, my submission is that the respondents may not be unseated. But if in the event this court feels that an advertisement ought to have been issued, then in future, at least an advice may be given to the government that if it requires the services of contract assistant professors, then in the event that may be advertised, but not in the case of the respondents, private respondents. That is my humble submission.
Respondent 9 has served for how many years?
He was appointed in 2017, so now it's 8 years running. It was a common appointment order. It's annexed in the writ petition, for which I have not. Yeah.
In this one, your relevant paras would be?
My apologies. I'm relying on paragraph 57. That's the conclusion. 57. 57.6 to be precise. I'm obliged.
Yes.
May I please, Lordship? My Lord, I'm appearing for 22 private respondents. My Lord, I'm just for convenience, I'm just serving the details of the private respondents. Yes. My Lord, these are the details, short facts. Like my learned State Council, Standing Council has made submission. These are all not regular, but based on exigency situation. They have been engaged. Only the word, every appointment is mentioned engage. And Lordship, on the right side, extreme right side, I have given the date of appointment also for all of them. When some of the private respondents were appointed in 2011, that time they were in schools and universities.
You have filed separate affidavits?
No, I have filed only one. In my affidavit, I have also raised those maintainability also, locust also, because they were in schools and colleges when I was appointed. Some of them was appointed. I have reflected, my Lord. These are the list for convey I have mentioned. One fellow was appointed in 2011, page 6. Page 6, respondent number 23, 11. Then respondent 21, page 5, last 13. 13, last respondent, according to respondent I have made, respondent 21. Respondent 21. Serially I have made. 13. Then coming to respondent number 24. 14. So then coming to respondent number 6. 2013. So these were appointed even before the petitioners have finished their MA or MSc. So therefore we have raised the locus standi that they have no locus to file this petition. This is not PIL. Lordship is aware. Yes, I have given according to the respondents list. So that can be official record. Instead of reading those affidavits, I just supplied this. My Lord, on the question of maintainability, my senior Sir City Senior Advocate and other colleagues have raised. So similar law points are involved in all these petitions. So therefore, I adopt the submissions of my senior Sir City and other colleagues who have made submission on locus standi, delay in filing. In my case, appointed in 2011, filing in 2022. And the petition is submitted before this court in such a way is very defective because they have not segregated. Non-sanctioned post, sanctioned post, qualified, not qualified, all this. So therefore, as my learned senior has made submission, in earlier repetition, I was also part of the council in that also. So on the same ground, Justice Nielsen had dismissed. So therefore, even today, same repetition is, same defective petition has been filed. So that is one area. Number two, my lord, like my brother Satwa Iralu has submitted, that case is pending here before division bench, where the petitioners are advocate challenging the appointment of grade 1 lower judicial officers. Appointment was absolutely illegal. But considering that they had the grade 1 judicial officer had rendered 6 years of service, so therefore, considering the land of service by them, let them not be disturbed. That is the relief given to the respondents. So similarly here, all of us, we have rendered more than 14 years, 11 years, 10 years. Some people, yes, not done. But therefore, my point is, petition should have been filed separately, raising certain grievances in all different cases, which is not done. So therefore, going by this 2024 Supreme Court judgment, Constitution bench judgment, I also say, look, this is the same case is pending before division bench here. So therefore, even in this case, that's quite covered our case, all the private respondents. That yes, initially it might be illegal, but now since they have rendered for more than 10 years and above, 9 years, 6 years and above. So that is one aspect. My lord, since this is not PIL, in the case of PIL, relaxation of procedural requirement is always given, considering the fact that the ordinary citizen cannot approach the High Court or Supreme Court. But this is not PIL. If it is PIL, like I said, relaxations of procedural requirement taken care by Supreme Court and High Court. Procedural lapses are always overlooked in PIL, but this is not PIL. And therefore, when the petitioner have come forward before the Sonoma High Court saying that my right Article 14, 16 have been violated. In 2011, 2013, 14, what fundamental right of the petitioner have been violated? That they should justify it. And that they should come out and explain. No explanation has been given. How the right have been violated in 2011, 13, 14. Because they have filed petition only in 2022. This is the basic things, my lord. So, on the whole, my humble prayer is that, like my learned senior friends and other colleagues have made submission, in the first place, this honorable court will see whether this petition is maintainable or not in the first place. Only after considering that preliminary things, merit will come. Yes, on merit, many of my candidates are not qualified. Some have qualified in service, while in PhD, NET, all this. That aspect is different. And that also they have not raised in the writ petition. That initially, these are the appointment, the hurdle for them is 2011, 13, 14, they were in college. How their fundamental right have been violated, infringed, one. Number two, in their petition, they have not explained in what manner, how I have acquired a NET qualification or PhD. That also I have not explained. So therefore, in my respectful submission, the petition is not maintainable at all. So only after considering that merit will come. Yes, merit, each and every case is different. But like I said, on the whole, the petition is not maintainable. Therefore, in my respectful submission, this is more court after going through the pleadings, may be gracious enough to dismiss. Lordship, I have supplied these facts, so I don't need to read out also. That these details. In my case, I have submitted, I have written my name at the bottom, so that there won't be any confusion. These are the correct facts, and these are all non-sanctioned posts. No doubt, there are a lot of Supreme Court judgment that in case of non-sanctioned posts, Supreme Court cannot lay down the law that judiciary cannot interfere and direct government to create posts. That is different aspect, but that principle also still applies here. So these are the particulars of the private respondent whom I am defending, my lord. Much of that.
May I please, Your Ladyship?
Yes.
Your Ladyship, I am representing respondent numbers 7, 14, 19, 24, 26, and 31. Your Ladyship, in order to save court's time, I would like to adopt the same submission made by my learned senior counsel, more particularly my senior counsel as your Lordship.
You are for R?
I am for respondent number 7, 14, 19, 24, 26, and 31. And Your Ladyship, with regard to detailed chart of the particulars of the respondent and the petitioner, if I may be allowed to make a, if I may be allowed to submit in the course of the...
Because that will make it easier.
Yes, Your Ladyship.
The date of your appointment, and then the date when you qualified, and then the date when the petitioner qualified.
Yes, Your Ladyship. I'll be submitting in the course
Yes,
of the...
yes.
Much obliged.
That's all.
I have not submitted, but since it's...
No, that we can, like I said, Thursday, Friday.
Friday.
You will be there. Friday you will be there.
Friday I will be
Yes,
there,
yes, we can continue on Friday then.
Yes, Lordship.
I think we have one more, no, in the list.
Thankfully, all the respondents have submitted.
Yes,
So
yes.
only
the reply.
Reply part is left.
One item 56 is there, I think.
Petitioner is absent today.
So,
I'm very glad.
sincere. Next week,
After 2 weeks,
after 2 weeks.
yes.
You've called, no?
For hearing, item number 56.
Yeah.
Already mentioned.
Chief has not passed any order. If something is kept on record,
Yes.
I think.
No, let the private secretary come. At least, let's wait for that. 188. First.
Also the citation, Mr.
Also, and this also. This and then these two photocopy has been made. Okay. Heard learned counsel sir, said you just give the names and then the parties, na? And learned Jackie is for the petitioner, and then learned counsel sir for the respondents. The matter is part third. Refix as a part third item on Friday.
That is
17th.
17th.
Then item 56. Yes.
17, Lordship.
Then item 56, learned counsel for the petitioner is absent when the matter is called. Learned additional AG, Mr. M. T. M. Song is present. List the matter after 2 weeks.
Obliged, Lordship.